Good morning. Welcome to the Maryland Public Service Commission. The commission will come to order. This is a continuation of our trial type evidentiary hearing in case number 9645. We're now at day 3 of the hearing. Are there any preliminary matters before we call BGE's next witness? Hearing none, counsel for BGE may call its next witness.
Good morning, Mr. Chairman, Commissioners. Your Honor, the company calls Jason Manuel to the stand.
Mr. Manuel, if you could please turn on your microphone and raise your right hand and wait for the court reporter.
Okay. Sir, do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
Mr. Manuel, can you wave if you could hear us? Okay, Mr. Manuel cannot hear us. Let's go off the record. Ms. Ravenel, can you get in contact with your witness?
Yes, I'm going to message him.
Ms. Ravenel, you may need to ask your witness to call in. I don't see a microphone icon for him.
Okay. I just sent him the call-in information. I believe he's trying to dial in now.
To remind all witnesses, if you have your call-in information at the ready, it's always good to have that as a backup. Manuel, are you with us now?
Hello?
Hi.
Hello. So I guess I'm gonna use my phone for audio and I'll use the video. I think you guys can see my video.
Yes, we can. Okay. Let's try this again. We'll go back on the record and the reporter will swear you in.
Okay. Thank you.
Do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Please state your full name, business address, and position for the record.
So my name is Jason Manuel. My business address is 110 West Fayette. I'm in Baltimore, Maryland. And my title is Manager of Revenue Policy.
Great. And what is your role in this proceeding?
So my role is to sponsor the gas cost of service study in this proceeding.
Do you have before you a document entitled The Prepared Direct Testimony of Jason Manuel, dated May 15th, 2020, consisting of 23 pages and 5 exhibits that has been previously marked as Company Exhibit 26 for identification purposes?
I do. Sorry, I jumped the gun there, Christia.
No worries. Do you have before you a document entitled The Prepared Rebuttal Testimony of Jason Manuel, dated September 11th, 2020, consisting of 14 pages that has been previously marked as Company Exhibit 27 for identification purposes?
I do.
Were the documents identified as Company Exhibits 26 and 27 prepared by you or under your supervision and direction?
Yes, they were.
Do you have any changes or corrections that must be made to any of these documents?
I do not.
If I were to ask you the same questions in each of these documents today under oath, would your answers be the same as written?
Yes.
At this time, I ask that Company Exhibits 26 and 27 be entered into evidence.
Hearing no objection, BGE Exhibits 26 and 27 are moved into evidence.
Thank you. The witness is now available for examination.
We'll begin the examination by counsel from Maryland Office of People's Counsel.
Morning. Office of People's Counsel has no questions for Mr. Manuel.
We will turn to counsel for Public Service Commission staff.
Staff has no questions, Your Honor.
Do any remaining parties have cross-examination for Mr. Manuel? Do commissioners have any questions for Mr. Manuel? Commissioner O'Donnell.
Thank you, Mr. Chairman. Mr. Manuel, I wanted to ask you, similar to what I asked Ms. O'Neill yesterday, what do you believe the impact of COVID will be or could be going forward with regard to allocation of costs to various classes of customers? And I'm specifically interested in what you think the changes may portend for due to COVID for residential versus commercial or industrial classes of customers.
So my response would be very consistent with witness O'Neill's response. Currently, we don't forecast for the cost of service study. You know, we're a backward-looking approach, but certainly the proposal that we have in our testimonies to average throughput and demand allocators will help to smooth the variations and the impacts of what happens in the future.
And on the gas side of the house, is it like the electric side of the house where the residential usage has increased? Do you have enough data to even know, and commercial and industrial maybe has decreased in an offsetting manner, so it's relatively, the demand is relatively constant? Is that true on the gas side of the house as well?
Are you referring to the impact of COVID on the gas line of business?
Yes, sir.
So on the gas side of the house, the demands are going to be greatly influenced by winter weather. And since COVID really happened post-winter, I don't think there's been much of an impact.
Not enough data. Okay, very good. Thank you. I thought that might be the case. I appreciate it. Thank you, Mr. Chairman.
Any additional commissioner questioning? Any questions based on Commissioner O'Donnell's questions? Thank you. The witness is excused. The company may call its next witness.
Good morning, Chairman and Commissioners. Beverly Sakura on behalf of BGE. The company would like to call David M. Vahos to the stand at this time.
Thank you, Mr. Vahos. If you could turn on your microphone, raise your right hand, and wait for instructions from the court reporter.
Yes, sir, Your Honor. Hopefully you can hear me on my screen. I still don't see the video.
We could hear you fine. Apparently you are having video trouble. You could either restart your connection or you might just want to shut your video down entirely.
All right, let me try that. And no luck on the restarting video on and off. Yeah, your video is working, so I can just move it. I don't think that's going to work, unfortunately.
Your Honor, sometimes you have to restart. You have to close and restart to have the camera work. I've had to do that.
Mr. Vahos, if you want to try that, if you want to close out and exit the room and come back in, well, we could try that.
Yes, sir. I'll try that. Thank you. Appreciate the patience.
Mr. Chen, if you could be on the lookout for Mr. Vahos if he's coming back.
Yes, Mr. Chairman. He's not tried to log back in yet.
There he is.
Apologize for that. I'm still on mute. So it's still no luck on the camera. It looks like. I'm pretty sure all the wiring's connected. So.
Okay, well, it's more desirable to see the witnesses, but with this situation, we see your cameras on, but we can't see you. So why don't you shut your camera down? That might help your audio quality.
Okay, and Your Honor, I can, if with your indulgence, I can move to one of the legal rooms, one of the counselors, in a couple minutes just to move my stuff, because that video is working in that room, if that would be okay?
That would be preferable, yes, if you could do that.
Yes,
Okay.
I apologize again for the technical difficulties, and I'll be logging off, and I'll be on that one. Thank you. Appreciate your patience, everyone.
Okay, so we'll remain off the record until we could get his up.
And all right, everyone. I hope I'm back here. Great, thank you. Appreciate everyone's patience. Sorry about that. It's always frustrating when it works on the trial run and then it doesn't work when we need it for real.
Okay, good to see you, sir. Let's see if your attorney is coming back on. Looks like she's trying to. And it now looks like we have problems with Ms. Sikora's video. Ms. Sikora, can you hear us?
I can hear you and I can see me.
Okay. You now apparently have the same problem that Mr. Vahos had a minute ago. If you're comfortable with not being on camera, we could proceed.
Oh, I am plenty comfortable with that.
Okay, why don't we turn your camera off? Oh, there we go.
Oh, can you see?
Oh, for one.
Mr. Chairman, I had her on camera.
Yeah.
Can you see me now?
Yes, we can.
Okay.
Okay.
Still would prefer I wasn't on camera, but that's okay. We'll go for it this way.
Okay, let's proceed if the court reporter is ready to swear in the witness.
Swear and affirm under the penalties of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
I do.
Good morning, Mr. Vahos. Could you please state your full name, employer, and position for the record?
My name is David M. Vahos. I am the CFO and treasurer for Baltimore Gas and Electric.
And the CFO being the Chief Financial Officer?
Yes, Chief Financial Officer.
Mr. Vahos, do you have before you a document entitled The Prepared Direct Testimony of David M. Vahos, Part 1, dated March 2nd, 2020, consisting of 24 pages and 6 exhibits?
I do.
Okay, Your Honor, this document has been pre-marked as BGE Exhibit 20. Mr. Vahos, do you have before you a document entitled The Prepared Direct Testimony of David M. Vahos, Part 2, dated May 15th, 2020, consisting of 73 pages and 6 exhibits?
I do.
This document has been pre-marked as BG Exhibit 21. Mr. Vahos, do you have before you a document entitled The Public Version of the Prepared Rebuttal Testimony of David M. Vahos, dated September 11th, 2020, consisting of 111 pages and 3 exhibits?
I do.
Your Honor, this document has been pre-marked as BG Exhibit 22A. And finally, Mr. Vahos, do you have before you a document entitled The Confidential Version of the Prepared Rebuttal Testimony of David M. Vahos, dated September 11th, 2020, also consisting of 111 pages and 3 exhibits?
I do.
Your Honor, the confidential version of Mr. Vahos's rebuttal testimony has been pre-marked as BG Exhibit 22. Were these 4 documents prepared by you or under your direction and supervision?
Yes.
Do you have any changes or corrections that you need to make any of these documents?
No.
If I were to ask you the same questions today in each of these 4 documents under oath, would your answers be the same as those that are written?
Yes.
Your Honor, I ask that BG Exhibits 20, 21, 22A, and 22B be entered into evidence.
Hearing no objection, BG Exhibits 20, 21, 22A, and 22B are moved into evidence.
Okay. Your Honor, I do have several rejoinder questions for Mr. Vahos that I would like to go through at this time.
You may proceed.
Thank you. Mr. Vahos, were you watching the hearing on Tuesday when Mr. Case talked about the alternative strain recovery mechanism proposal under the MYP?
Yes.
And I presume that you heard when Mr. Case said that you had prepared the revenue requirements exhibits showing this alternative proposal, and
yes.
that you would be prepared. You didn't let me finish.
Sorry.
And that you would be prepared to provide further information when it was your time to come to the stand?
Yes.
Your Honor, I'd like to turn to BG Exhibit 72. That was sent to the commission and the parties yesterday morning.
If you could give us 1 moment, and just a reminder for the witness, please no crosstalk. Wait for your attorney to ask you the question.
Yes, sir.
Ms. Corey, you said exhibit number 72, is that right?
Correct.
Okay, thank you. Please proceed.
Okay. Mr. Vahos, just to confirm, did you prepare this or was it prepared under your supervision and direction?
Yes.
Okay. Mr. Vahos, can you please explain how the alternative stride recovery, cost recovery proposal, the alternative is reflected in these revenue requirement calculations that we provided?
Hold on, Mr. Vahos, I'm still looking for 72. I have up through 71. I'm trying to find 72. So
okay,
if you could hold off.
Yes, Commissioner.
'70, 71, 72, and 73 were all sent around at the same time yesterday.
Thanks. I have, there are two of them. One's a chart and one's or are they both the same?
They're both the same. One is the PDF version, which may be easier to look at. The other one is the Excel version in case people want to dig into the formulas and kind of see where all the numbers are coming from.
Okay, I appreciate it. You can proceed. Thank you.
Okay, Mr. Vahos, can you now explain how the alternative stride proposal is reflected in the revenue requirements?
Absolutely. And again, good morning, everyone. So, what we've done here is, as company witness case described earlier, is reflect the scenario, if you will, or an alternative, as I touched on in my rebuttal testimony, where the stride surcharge is set to 0 for the pendency of the MYP period, so 21 through 23. And what that does is it affects base rates, right, versus what we originally filed. So what we have here in Exhibit 72, if I may just direct you to the first page, is we've highlighted in yellow where we have made changes from rebuttal testimony. So it would be easier for the parties and for you to see what lines have changed and which ones have not. And what we've done is we've maintained our position that we continue to advocate for a no revenue requirement increase in the first 2 years of the MYP. So 21 and 22, as you see, remain unchanged. And what you'll see is there's almost 2 new rows, if you will, at the very bottom before all the numbers for the conversion factor. You'll see revenue requirement filed in rebuttal testimony of 91 million, right? So that is compared to that's what we filed in my rebuttal testimony, to be clear. You'll see right above that is 148 million now. And that difference is the fact that we've included 0 revenues for stride in the surcharge. And what we've done is we've moved some of the tax benefits around to make sure that those first 2 years stay at 0. That's why you see more of a bigger impact in year 3 than you would have anticipated. So that's the math. And then, of course, behind all of this sheet is all the other sheets, again, highlighted in yellow, that support the changes that we made and tie back to this lead sheet, I'll call it. So I'm happy to answer any questions your honors have.
Would you like me to proceed or did folks have questions now?
No, continue with your live rejoinder. Commissioners will hold their questions till the end.
Okay, sure. Mr. Vahos, OPC witnesses Alvarez and Stevens disagree with your rebuttal testimony when you say that the focus of the MYP should be on the MYP years, which are in the future, and this proceeding should not devolve into a referendum on capital expenditures that have already occurred. OPC witnesses Alvarez and Stevens explained that the spending at issue during the case number 9610 test year, which resulted in a settlement, can still be reviewed because the commission never decided on the prudency of the spending. Do you agree with OPC witnesses Alvarez and Stevens about the commission's ability to review the prudency of spending in 2019 and 2020?
Thank you, Counselor. And I actually appreciate OPC pointing out that particular part of my testimony to me. I was not as clear and artful as I should have been. I was not suggesting that the commission does not retain its ability to perform a prudence review, nor was I suggesting that in fact they shouldn't do that, right? Because they have a public interest standard that they're trying to meet. So I wasn't as clear as I should be. So I appreciate the opportunity here to clarify my point. I don't agree with the Office of People's Counsel that we can go back to a prior case, 9610 in this instance, and revisit investments from that case. Now I realize I'm not an attorney, so take the finance guy's opinion for what it's worth. But my understanding is that regardless of whether it's a full adjudication or it's a settlement, once we have a determination that we have just and reasonable rates that are used for the provision of service, that's a done deal, and anything going back to that would be retroactive rate making. I think the other point that I failed to make as clearly as I should have really relates to some of the investments that are being discussed that were actually reviewed, I'll say in a sense, in case number 9353. That was the reliability hearings. And in those hearings, we set new performance standards for electric distribution, and also costs were a part of that review process. And so while, again, I could have been more artful in my rebuttal, I'm not suggesting that the commission can't look at what we're spending or proposing to spend, but I would ask that the commission consider all the valuable work that happened in 9353 about the reliability and about the work that it would take to deliver that reliability, because I just think it should be something that we consider. I should say something that the bench considers, pardon me, as they consider what to do with OPC's proposal. I think the only other fact I'll add about 9353 is we raised the, I'll say, concern that we have reliability targets that we're being held to, and we welcome that. But coming with those reliability targets was a series of work that we had demonstrated. And in fact, staff asked a discovery question about whether or not the work that we had shown in 9353 is in the MYP. In fact, it's a little bit less. So the work from a cost perspective is actually a little bit less in the MYP. But I think it's a little bit unfair to say, stop doing the work, but not suggest that perhaps those performance standards should have been revisited. So I think in that sense, I think it's a little bit unfair what OPC is proposing.
Thank you. Moving on, Mr. Vahos, OPC witness Larkin Connolly takes issue with your defense of the MYP budget when you said that the MYP budget is the same budget that we present to investors. According to Mr. Connolly, he says that financial plans should not be used to set rates, and rates should not be set, and that rates should be set based on the actual tangible work that we have identified. Do you agree with Mr. Larkin, or do you agree that BGE's MYP budget is solely a financial plan and not based on the actual tangible work we have planned?
No, I do not. I don't agree with that at all. And I appreciate the question. And I think Commissioner Herman, if I remember correctly, has asked a similar question about is the workforce first or is the budget first? Let me be unequivocally clear. The planning process, if I may have a moment, Your Honor, just to kind of provide that context. The planning process starts with actually the customer. So what do we need to do from a safety perspective? What do we need to do from a reliability? What do we need to meet customers' expectations and satisfaction? That actually generates a series of company objectives. So if you think about safety, KD, you think about cycle time for leak repairs, you think about service level in the customer organization, those are the metrics that the leaders that we had in this case earlier are actually using through their teams, obviously, to develop work plans to deliver those outcomes. And those work plans are then translated into dollars. So that's where my organization comes in. The finance organization comes in and helps these leaders who have operational objectives that are designed to meet customer needs and commitments are translated into dollars, right? We have over 300 projects in this proceeding, and that's how those things were generated. Now, when I meant that we share that same view with investors, it was actually to give everyone comfort that we take that same level of rigor around the work that we need to perform. We translate that into dollars. We then go ahead and capture that and share that with the board, share that with investors, and that is exactly the same thing that is in this MYP filing.
Thank Thank you. Mr. Vahos, in response to our concerns about the significant reductions OPC is proposing to our MYP budgets, OPC witness Larkin Connolly says that it seems that BGE believes it's more acceptable to overcollect and then have to return funds to customers than to undercollect and have to wait to recover the costs. He notes that you emphasize that the asymmetric application of carrying charges to overcollection balances will ensure that customers are held harmless, but that BGE having to wait for future recovery is, and this is a quote from your rebuttal testimony, entirely unworkable. Is Mr. Larkin Connolly's characterization of your rebuttal testimony accurate?
No, it's not. It's taken entirely out of context. And if I may have the commission's indulgence, I'd actually like to read just a very short passage from my rebuttal that I think captures succinctly what I was talking about when I was saying entirely unworkable. Great, thank you. So it's on page 36, I believe, for reference. But so here's the short passage. So investing $1 billion outside of the MYP with 2 years of frozen rates with significant reductions in cost of service and one of the lowest ROEs in the nation would negatively impact the company's financial metrics and be entirely unworkable. The company simply does not have the capacity to absorb the combination of these impacts. OPC's suggestion that such an alternative exists is simply erroneous and must be rejected. So if I may, it might help if I explain a little bit further to give that further context, Your Honors. So if you look actually, which I realize it's kind of hard to see the entire proposal from OPC because they have a lot of things and a lot of different witness testimonies, but it's actually even larger than a $1 billion reduction in the MYP. If you go all the way back to 2019, which is what they propose in their testimonies, it's actually $1.5 billion of capital that they would be proposing to take out of the MYP period. And what this creates is almost a two-world model, right? We would have a model where some things are being put into the MYP, really delivering kind of the outcomes that we all aspire for in the MYP: transparency, predictability, rate stability, regulatory lag, those benefits that would be in the MYP. But then you have another significant portion of capital, $1.5 billion, that would actually be worse than the old historic test years. Because at least in the old historic test year model, I could at least ask every year for some form of relief. But with the MYP and the stay out, I'm actually prohibited from asking for any form of relief. And so we actually make what typically is a 1 year lag become a 2, 3, or 4 year lag, depending on the investment that we're talking about under OPC's proposals. And clearly that is not workable when you think about my ability to raise capital and actually maintain the credit health of the enterprise with that kind of an impact on my business here as BGE. So the other thing that concerns me about OPC's proposal is the rate shock element. So even in that hypothetical, even if I could, which I can't do that from a financial perspective, we would be rolling in $1.5 billion of capital in 2024. That's what the outcome would be of that kind of a proposal. So you really can't have this hybrid model where a significant amount of capital is put outside of the MYP and fully achieve all the outcomes that we're trying to achieve in this proceeding.
Thank you. Moving on again, Mr. Larkin Connolly originally recommended that all of the costs in Project 64713, which is the EU digital program, be removed from the MYP. But after your rebuttal testimony, he reduced the amount to be removed. He didn't withdraw his recommendation entirely because he says we only provided the budget for 2020 and 2021, and because the amounts for those years and the support we provided for the project are less than what's in the MYP. What is your reaction to Mr. Larkin Connolly still reducing the budget for Project 64713?
I think in fairness to Mr. Larkin Connolly, there's a lot of documents, a lot of pages, a lot of information that was shared. So I can see why he would have missed a page in a document and would have reached an erroneous conclusion. If you go to DMV 10, which is in my rebuttal testimony, it's the last document in my testimony. And if you were to go to page 4, you would see a BGE budget by year for the digital program. And in fact, those dollars are exactly the same dollars that are in our MYP filing for that particular project. So again, lots of paper, lots of documents. I can see where someone would miss a number. But I just want to take this opportunity at least to clarify that those, in fact, do agree.
Thank you. Again, OPC witness Larkin Connolly makes no change to his recommendation that the entire budget for project 66379, which is called the IT projects, be removed from the MYP. In his rebuttal testimony, he seems to acknowledge that you provided examples of the work under this project in your rebuttal, but he says that you still have not identified project work and that you didn't say that the example projects would actually be, that the company would actually carry those out and commit to carry them out under the project. And this is why he would continue to recommend that the entire budget for that project be eliminated. What is your reaction to Mr. Larkin Connolly's reasons for continuing to recommend that the entire budget for project 66379 be removed from the MYP?
Yes, let me start with, I think I have to go all the way back to direct, if I may, for a moment. In direct, a witness, Larkin Connolly, suggested that there was no work behind this particular project. And I think in fairness, and we heard this from staff as well, that we didn't provide enough specificity in terms of what we were doing early in this proceeding. That's definitely a lessons learned. We will definitely take that to heart in future proceedings like the MYP. But so we did provide in rebuttal testimony a view of the entire world of IT demand. And so what is IT demand? That is actually all the work that the vice presidents and leaders of BGE have identified as IT investments that need to be made to continue to maintain the system, okay, and operate it efficiently and effectively. And if you think about cyber, you can see a world where we want to keep these things very healthy, very vibrant, very current, obviously. And so there's a lot of life cycle investments in that kind of a scenario, customer, digital, et cetera. So we provided that view, and we described some of the things like gas SCADA upgrade as an example. And then what was interesting is we got a data request after our rebuttal testimony, where OPC's witness asked for, well, can you give me a list of that IT demand by subcategory? So again, think life cycle, customer, and we provided that. I'm happy to give that to OPC. And then honestly, it was radio silent. And the next thing that we heard is in rebuttal, that OPC witness Larkin Connolly raised these, I'll call them these new concerns, quite honestly, that weren't ever raised before. One of them that we didn't give detail. Well, we never got asked to give any more detail after our first data response. And then secondly, that we aren't committing to do all the work that's in that IT demand, but that kind of falls apart for me logically, because we're saying that IT demand from the vice presidents is greater than the budget that we have. So I can't commit to do all that work. I'll commit that we're going to prioritize and get the work done within that budget. That I can do. But I don't think it's fair to ask me to commit to get all the work done when it's actually more than I have in the budget.
Thank you. And this is the last question I'll have for Mr. Vahos today. Again, in his rebuttal testimony, OPC witness Larkin Connolly continues to recommend that nearly the entire amount of the budget for projects 60832, which is a renovations capital lifestyle projects, be eliminated. His reasoning is similar to the reason for why he is disallowing the IT projects that we just discussed. He says that we still haven't identified any specific work under the project, and so we shouldn't get cost recovery at this time. How do you respond to Mr. Larkin Connolly's claim that we haven't identified specific work under this project?
It is very similar to the IT theme. Again, I think we've learned a valuable lesson that we can do more earlier and so that's on us. But at least in terms of rebuttal, we did provide a list of 5 properties that, we're actively seeking to work on or are working on. If you think about Perry Hall Service Center, Howard Service Center, the Genie headquarters building that has 800 employees in it, the Spring Gardens campus, which is the gas headquarters for both field as well as office, and the Lord Baltimore building, which is a mix of warehouse and office. So all of those areas we're seeking to improve those facilities. They're old, in some cases very old, and so we shared that in rebuttal. And so it strikes me very similar to kind of the IT situation where, again, legitimately could have given more heading into his direct testimony. We addressed that in rebuttal, and now it's kind of, well, you didn't give me enough, but there was no data request that I recall seeing after my rebuttal where he asked for more information and that we didn't provide. That just didn't happen.
Thank you, Mr. Vahos. That's it for the rejoinder. Your Honor, I don't recall if I asked that BGE Exhibit 72 be moved into the record. If I didn't do so, I would at this time.
You did not. Hearing no objection, we will move BGE 72 into evidence.
Okay. And with that, Mr. Vahos is now available for cross-examination.
We'll begin the cross-examination by counsel for Walmart.
Yes, thank you, Your Honor. Walmart has no questions for this witness.
We will next move to counsel for Maryland Office of People's Counsel.
Good morning, Mr. Vahos. I'm Anna Ryan for the Maryland Office of People's Counsel. I do have a few questions for you. I'll try to keep my part in this short since it sounds like there are going to be a lot of other questions from others involved in this proceeding. I'd like to start with a quick follow-up to the live rejoinder that you just did. And one of the things that you mentioned was that using historic test years, if you needed additional funds, you could come back to the commission and ask for another rate increase to get those funds. But with a multi-year rate plan, you're prohibited from doing that, and that actually increases regulatory lag. Am I understanding your testimony correctly?
Good morning. So I didn't get a chance to say that. Good morning. Sorry. I think you're close. If I can take a moment and try to clarify. So I was reacting to some of the OPC witnesses' testimony that to the extent that the commission felt these investments were prudent, and we do, that's why they're in the MYP. That to the extent we felt these investments are prudent, that the company has an alternative to deploy those, in my language, deploy that capital, make that investment outside the MYP, and that we wouldn't be prohibited from seeking recovery effectively at the end or after the MYP. Okay. And so if you think about that scenario for a moment, is what I was describing financially speaking. And again, I'm going to use OPC's entire position in this litigation. They're proposing that we take out $1.5 billion of capital investments from 1920 all the way through 23. And then they're saying, okay, well, we'll wait to actually put those costs into base rates until, I guess the earliest would be, in fairness, that reconciliation that would occur in 2023. But those rates wouldn't go into effect until 2024, if that makes sense. So, and because there's a stay out provision in the MYP, I would be prohibited from taking any action on that $1.5 billion to try to start cost recovery, right? That's a part of the MYP framework that there's a stay out. So it actually is significantly worse than just your normal historic test year. Because again, in a normal historic test year, to the extent I'm deploying capital on things like gas infrastructure or electric infrastructure, I would have the opportunity to file a case whenever I felt it was necessary because I had a significant revenue deficiency. That option is gone in the MYP construct. And that presents this problem of it's worse than a historical test year. And that also presents the dilemma of it's going to be really not workable, I'm going to use my words again, to try to finance that outside of an MYP without rates and try to keep the financial health of BGE where it is today. Hopefully that
BGE
clarified it.
volunteered to be the company running the pilot multi-year rate plan with the commission, correct?
Yes.
And BGE was not obligated to file both the gas and the electric rates plans at the same time, correct?
We were not.
Okay. I also have a follow-up question. I believe you were listening yesterday when my colleague, Mr. Cleaver, questioned Mr. Case.
I did, yes.
Mr. Case referred a question to you that I just want to follow up on. And Mr. Cleaver was asking whether or not BGE would commit to including project lists with the annual filings, including both the status of the projects that were previously completed and any new projects that were not previously disclosed. Case referred that question to you, so I was hoping you could elaborate on that.
I'd be happy to. Thank you. I appreciate that. So there's two different things that are happening, if I may, Council. So the first is the project list. So every year the company will be filing a project list. And obviously, because we're talking about a budget that was created in the fall of 2019 versus expenditures in 21, 22, and 23, I'm going to know more about the projects as we get closer to each, I'll call it prompt year, or the year that we're executing. So we'll absolutely be providing that project list per the commission's implementation order. And as we see new details, new projects, again, that we don't have specific designs for all the way out through 23 today, we would go ahead and absolutely make that transparent. Now, with respect to the informational filing, I did appreciate the chance to look at the commission's order again. So I did go back to that, and in the appendix, I think, or at least at the back of the commission's implementation order, they basically laid out a template that had come out of the working group as the process for informational filings and for the reconciliations. And that actually is done at what I'll call a category view. So it's not a project by project view of expenditures. It's actually more of like a, electric corrective maintenance as an example, right? So not the projects, but that category of spend. So what we would envision doing is going ahead and producing both the project list with the latest and greatest information every year and completing the template as the commission designed in its implementation order. And then, of course, to the extent that there are any questions, categories, people want to see a project, of course, we would work with the parties through the discovery process that the commission has created.
You're on mute.
Sorry about that. You'd think I'd have have things worked out by now. But I have one additional question regarding the performance adder proposed by BGE in this case. And that's basically when arriving at the amount of the adder, does each point reflect a specific value? Is there some sort of measurement on which you're adding points, or is it just an overall number that you feel is fair?
Appreciate that question as well. And if I recall, at least one, if not more, commissioners have asked a few questions. In fact, Commissioner O'Donnell, as I recall, even yesterday, kind of raised a concern about how that could work with the PIM. So if I may take a moment, I'm going to diverge a little bit from your question, Counselor. But look, at the end of the day, we're not going to be saying here you absolutely have to have a performance adder discreetly, captured and computed and separately from the ROE. We understand that that's probably not going to happen. And so I don't want to make it sound like we're not aware of that. I do think, though, as a matter of policy, that strong performance, top tier utility, top quartile, top decile performance should be recognized in the determination of an ROE in the range of reasonableness. I think OPC agrees with that, if I remember correctly from the server rebuttal testimony. And in fact, this commission has done that in its past And in fact, it was for BGE. It was case number 9036. It was a similar situation. We had asked for explicit adder for the gas performance heading into that rate case. The commission made the determination that it didn't want to do that, that it instead would take that performance into consideration when it deliberated and made a judgment about the proper ROA for the enterprise. So I don't want to spend a lot of time on this kind of topic for the bench. We're perfectly happy if we could just, have the bench consider our performance. We really do think top quartile, top decile performance is valuable to our customers. And we think that it should be, I guess, recognized in that determination of ROE from a public policy perspective.
So there are no specific measurements that were involved in arriving at, the amount of the adder. It's more of an overall judgment.
It's definitely a judgment call.
Okay. That is all I have for you, Mr. Vahos. Thank you for your time.
Thank you. Appreciate it.
Do other parties to examine this witness?
Staff has a little bit of cross for this witness here, Mr. Chairman.
Mr. Spivak, you may proceed.
Thank you. Good morning, Mr. Chairman, Commissioners. Lloyd Spivak for the Commission staff. And good morning, Mr. Vahos.
Good morning, sir.
Okay. Can you please refer to page 49 to 50 of your rebuttal testimony at starting at line 19 of page 49?
I'm on page 49, Counselor. You said line
19.
Line 19. Yes, sir.
Yes. And there you refer to annual information filings and the reconciliation process to deal with potential circumstances where actual revenues are higher than forecast. Is that right?
Yes, sir.
Okay. Do you think there could be a situation where there is over recovery of revenues relative to forecast for a particular class or group of classes, while other classes have revenues that are approximately equal to forecast revenues?
So you're, Counselor, just so I'm clear, you're talking about customer tariff classes?
Yes. Well, the various rate classes.
That's like delving into cost of service and how cost of service was assigned. I really am unfortunately not in a position to say whether one class hypothetically could be worse than what the cost of service study would have assumed in that rate design ultimately than another. I'm more of the revenue requirement overall, so I can definitely talk about that, but to start breaking it down into classes is just not an area that I've studied closely.
Okay. Is this something that would be appropriate to ask BGE's rate design witnesses?
I'm sure you could ask Mrs. Fiery, pardon me, but I'm not sure if that's Mrs. Fiery or the cost of service. It's an interesting question, I guess is the way to think about it. I'm not sure, you can ask her, but I'm not sure she's going to have an answer.
Okay. But in any case, then the reconciliation that the company is envisioning, then that would be an overall reconciliation. It would not be broken down by class in any way. Is that a fair statement then?
You mean the reconciliation that takes place in 23 and then the beginning of 24 effectively?
That and anything that's done with reference to the annual information filings in terms of over recovery of revenues.
On the informational filings, if I remember the commission's implementation order template, I didn't see anything about doing anything from a customer class perspective. I saw that all as being more about revenue requirements relative to the MYP budget revenue requirement, again, with some details around category. In the reconciliations at the end, when you're calculating the two difference for the true up, then I believe company witness Fiery has produced a recommendation about how that would happen and how that would flow through from a rate design perspective.
Okay, thank you for that.
Mm-hmm.
All right, moving on. Let's go to page 4 of your direct testimony, please.
Is that part 2, Counselor, or part 1?
Part 1.
Part 1. Okay.
It's the actual testimony portion as opposed to all the tables.
Gotcha. So, yep. I'm there, Counselor.
Okay, and this is a little more on the adder that you just discussed with Ms. Ryan.
Mm-hmm.
And you discussed the proposed BGE performance adder there, correct?
Yes.
And at lines 8 to 9, you state that the 35 basis point adder BGE proposes is in recognition of BGE's outstanding performance and customer satisfaction results. Do you see that?
Yes.
And that, in fact, is what you just said to us in the response to Ms. Ryan, correct?
Yes.
Okay. Am I right in concluding that if the commission grants it or any sort of performance adder, BGE would receive this adder simply for having reached its current level of performance?
You mean, is it strictly a reward for past performance versus, I see it as almost a twofold thing, Counselor. I think, yes, it's a recognition of a top performing operational utility with, record-breaking customer satisfaction, but it's also an incentive or an encouragement to continue to achieve that, right? To keep striving to be the best utility that we can be for our customers. So at least in my mind, I see it serving two purposes, not exclusively a retroactive review of performance, but an acknowledgement and an incentive to continue.
Okay. But BGE's proposal doesn't have any provision to reduce or eliminate this adder over the course of the MYP in the event of any significant declines in BGE's performance, does it?
No, that's fair. We do not.
Okay. Thank you. Okay, on page 9, I believe it's your direct testimony. You discuss the treatment of allowance for funds used during construction and construction works in progress. Is that right?
Yes, sir.
And can you describe for us what the function of these mechanisms is and how they work?
So how construction work in progress works in tandem with the allowance for funds used during construction? Is that the question?
Yes, very much so, but also just briefly what the function of those mechanisms is, what they're intended to do.
So maybe I'll start with AFC, or allowance for funds used during construction. That is very much a regulatory construct. It basically says, to the extent, in our case, from a policy perspective, you have investments that take longer than 30 days to complete from when you start to when you're done, you are going to go ahead and accrue or earn an allowance for funds used during construction. In Maryland, that has been the rate of return. And so those assets that take longer than 30 days earn that return over time as they sit in that CWIP account. Okay, what that does, especially in Maryland, where historically CWIP has been in rate base, is it actually lowers the cash return that customers have to pay, because construction work in progress sits in rate base as an asset, but then we include all of that AFC as income for rate making. And so what you end up having is some of our compensation as a company takes the form of non-cash. And so customers are insulated from paying for those assets that are earning an AFC non-cash return. I know that was a lot of technical jargon. Apologize for that. Hopefully that was clear. Oop, I can't hear you, sir. Oop.
Sorry, I was muted. That is somewhat clear. But what do you mean by a non-cash return there? How does that play out?
AFC is non-cash, so it's kind of an accounting exercise, right? We're recognizing a level of earnings off of that asset that sits in CWIP, but it's not actually in base rates, right? So we recognize the earnings, we include that earnings in rate making, and therefore that level of earnings is excluded from cash rates when you think about how base rates are derived in an adjudication.
Okay, and just following up on that, and that's because essentially base rates are set prior to the capital work that is actually being done. Is that a fair statement?
Because that CWIP is sitting in Maryland rate base, and so it's earning that non-cash return, or that AFC, to say it more clearly. That's because both of those sides, if you will, the asset side as well as the profit and loss or income statement side of that transaction, are sitting in our rate making construct in Maryland historically. So that's what makes sure that doesn't get into base rates.
Are you familiar with staff witness Falcarengi's proposal to remove quick balances from the development of rates?
I am.
Do you disagree with Mr. Falcarengi's statement, which is found at page 18, lines 4 to 7 of his direct testimony, that BGE should not be disadvantaged by staff's decision to remove the balances because it will continue to accrue allowances for funds used during construction while the plant is under construction?
No, I don't agree. So, and if I may elaborate.
Please do.
Thank you, sir. As I mentioned when we were talking about this a little earlier, the assets in CWIP that earn that AFC are investments that take longer than 30 days. So now imagine a scenario where we start a relatively simple either electric or gas job. We start in the middle of January and we finish by February the 2nd. It doesn't meet the 30-day criteria, so therefore it will not earn any AFC, but it is actually in CWIP. And so what happens is we always have a level of expenditure sitting in CWIP, historically in rate base, which I'm still advocating for, obviously, but sitting in rate base and sitting in CWIP that is not earning a return. And that number can be 70 million, 80 million, 100 million in any given month. Okay, because there's always new work coming in as new work comes out. And net, we always have a position in CWIP that is not earning AFC. So if we take CWIP out of rate base for Maryland rate making in an MYP, we have in fact taking it's clearly not as large as the step we're taking in the MYP, but we're taking a step backwards because we actually are creating regulatory lag that I didn't have before. Because I have a permanent level of CWIP that doesn't earn an allowance for funds used during construction. And that's really what it is. It's that nature. And so if you think about it, I'm thinking over the whole MYP. Every single month in the MYP, we'll have 70, 80, 90 sitting every single month. What's really happening is every single month, you've got assets coming in and out and going in service almost immediately, right? So you're talking about an asset. Love my January example. Let's assume it's January 2021. We have, again, that asset that started construction in the middle of January. And then in the first day or second day of February, it goes into service. And it's in service for the entirety of the MYP period, right? So 35 out of the 36 months, that asset in my example is in service and it's used and useful. So I do think that we should continue to include CWIP in rate base. I do think it was an important step that the commission took decades before I even got here. And I still think it meets a purpose that's consistent with the MYP objectives.
Okay, thank you. Moving on, have you provided information showing or describing the level of construction that does not accrue AFUDC for each year of the forecast plan?
No, and that is a fair criticism. There is a limitation, unfortunately, in my budgeting and planning technology that I can't produce that number today. I did talk to my team about whether we could, moving forward, basically change my system such that we could produce that view going forward into a future MYP. We are confident that we can do that going forward. Obviously, couldn't do that now, unfortunately. Otherwise, I would have produced it. But that doesn't change the fact that that will actually be there, right? So I realize I can't produce that view in the budget, but looking historically, there has never been a month ever in my almost 25 years here where we haven't had a level of CWIP sitting in rate base that doesn't earn AFC. So it's not like it doesn't happen continuously. It does, but I admit and I agree. Unfortunately, I have a limitation of what my tools can produce today. But you have our commitment that to the extent the commission were to allow CWIP to stay in rate base, that we will absolutely make the changes that we need to make in our technology to provide that view to stakeholders in the process.
Is it possible that you would be able to do that over the course of the MYP, that is, provide some sort of running or annual accounting of that?
I can definitely give an accounting of actuals because we always have that one. But yeah, I think over a 3-year period, yes, I'm confident we could improve the tool to provide some view of that for the parties, if the parties would like to see it. It's just if you'll give me some leeway as to how quick my team can produce that, that would be appreciated.
All right, thank you. At page 39, line 21 of your rebuttal testimony.
Give me 1 second, Counselor. I'm sorry.
Okay.
You said 39, Counselor, correct?
Yes.
Okay, and if you wouldn't mind repeating the line number, I apologize.
I believe it's line 21.
Okay.
You state there that the historical test year had approximately $84.6 million of construction that did not accrue AFUDC. Is that correct?
Yes.
Okay. Is that a total for the year as a whole, or is that an average of the monthly totals?
That's the average of the monthly totals.
Okay, thank you.
Yep.
All right, moving on. This is references a data response. It's BGE's response to staff DR 5904, and it's referenced in Mr. Valcarengi's rebuttal testimony at line 7 of page 3.
Can I have a moment to turn around, and I got a paper copy?
Okay.
Thank you. Hopefully I can reach it without losing this headphone. You said it's Mr. Valcarengi's testimony?
Mr. Valcarengi's rebuttal.
All right. Hey, look at that. Third one. That's always helpful. I have it.
And it is on page 3, and he references it there. Okay. And he notes that this data response indicates that BGE's budget systems do not forecast the level of construction that does not accrue an AFUDC. Now, based on what you were just discussing, that's an accurate statement, is it not?
Yes, yes.
Okay. Thank you. Okay. Going back to your rebuttal testimony, you discussed how BGE develops its capital and operation maintenance budgets. Is that right?
Yes.
Does BGE's capital budget include all of the projected expenses for STRIDE projects in years 1, 2, and 3 of the multi-year plan?
Yes.
Okay. Beginning on page 26 of your rebuttal testimony, you give your response to OPC and staff regarding STRIDE. Is that right?
Yes.
Okay. I'd like you to clarify a few things on the record for us regarding how STRIDE will work in the context of the multi-year plan. First of all, are all STRIDE eligible projects included in the STRIDE surcharge aspect of the multi-year plan?
In terms of the company's original proposal and the company's alternative proposal, like both answers, or just one in particular, Counselor?
Let's do the company's original proposal. I think the answer for the second is no.
Yeah. So the answer for the first is it's and I think Mr. Case described this. We were envisioning a kind of hybrid model where you would have some assets that are being recovered in the surcharge, effectively 20 and 21, most of 21 in our proposal. And then for assets beyond that, they would be in the base rate MYP rates. And that's what we envisioned. So again, a hybrid model. I think.
Okay.
Sorry, didn't mean to cut you off. I apologize.
No, that's fine.
I think in the alternative, I was anticipating your question. Yeah, we're looking at setting the surcharge in this alternative to 0, which I think is where staff is. I don't want to speak for them, but that's my reading of the last round of testimony. And I think OPC at least said they would not oppose or object to that outcome. That was witness Larkin Colony. So in that world, then you've really set the surcharge from day 1 to 0, and the STRIDE program investments would be all in the MYP base rates.
Okay. And those would not show up until year three of the plan. Is that correct?
In the alternative, they would be there. Well, I'm sorry. Yes. And what we're proposing to do to make sure we keep revenue requirements flat, yes, the revenue requirement impact would not be seen until 2023, because we made sure that by moving some of the tax benefits around, and that's I think it's Exhibit 78, the one I talked about this morning. Oh, 72, pardon me, 72.
Right.
But the investments are in all 3 years, obviously.
Okay. Is it correct that in this case, BG is including all STRIDE projects completed to date, meaning during the historical test year and the bridge year to date, into rate base?
Yes.
Okay.
Consistent with all the other investments we're making, right, in the bridge year as well.
Okay. And is BG moving anything else into rate base that's associated with the STRIDE at this time?
Beyond what you described of the investments after 19 and then into 2020?
Correct.
And then and I guess you could say 21 through 23, right? They're all going into MYP base rates, if that makes sense.
It makes sense. And now just clarifying that though, they're all going into the base rates on a projected level, but the impact, as we just discussed, doesn't show up in rates until 2023, correct?
Exactly.
And presumably the individual projects aren't going into base rate until they're actually at least in progress. Is that a fair statement?
You mean in terms of actuals, like what's going to happen in the book of record when we actually do actual rate base?
In terms of actuals and in terms of flowing through to the revenue requirement, they're not actually included in the rate base and earning a return until the individual projects are actually started
or completed. Yeah, yes, they're absolutely correct. So like all the other investments, whatever we really execute, right, across all of the investments we're making will be reflected in the informational filing, right, the multiple information filings, and ultimately that reconciliation in the end. And we'll be comparing to this MYP budget that we filed in this adjudication. But you're correct that as we see things have variance, and they will, it's the nature of construction for sure, all of that would be captured in those informational filings and ultimately trued up in the reconciliation.
And given that forecasted STRIDE projects would be in rate base now, but are not completed until various other time points over the course of the multi-year plan, how is the return on these projects handled in that instance?
I'll do alternative 2 because I think that's where most people are leaning, or the 0 STRIDE surcharge, if I may. So in that one, it's going to be like all the other assets that we have, right? As those assets actually go into rate base, they'll earn a return. In my proposal, to the extent that they're sitting in CWIP and they earn an AFC return, then that would also be included in the informational filings and the true up. To the extent that you're an asset that does not have AFC, then you would start earning a quote unquote return for informational filing purposes and the reconciliation once we start construction. And that's basically how it happens today. There's really no difference.
Okay. Thank you for the clarification. Okay. Now you just filed Exhibit 72 yesterday, and that's the company's calculation of its revenue requirement reflecting full recovery of STRIDE and base rates the alternative two we've been discussing. Is that right?
Yes.
In light of this, and as well as Mr. Case's rejoinder testimony, what is the company's current position with respect to how Stride investments should be recovered? Is the company's preference still its hybrid proposal, or to do it this alternative two, or which is the company advocating at this point?
Yep, I understand your question. We continue to remain kind of, I'll say, open to both. We think both options are consistent with the statute. We think both options demonstrate how, Stride and MYP can work together. If parties, and they have, if OPC and staff have expressed a preference for this alternative, or at least won't oppose this alternative, then we would be happy to move in this direction as well. There is a little bit of, I'll say, administrative ease in the alternative proposal because there's no surcharge activity going on. It's set to zero. I know we said it early with Mr. Case, but I think it's important to reemphasize it. In either one of these alternatives, you have the company's commitment that we will continue to provide the Stride list. We continue to have semi-annual reports. We'll continue to conduct the audit. So regardless of what form this takes in the MYP, those important protections that were created by this commission will continue.
Okay. So what I get from that is essentially the company is agnostic as to which alternative the commission ultimately chooses.
I agree with that.
Okay. Now, just if I'm recalling from what we saw in Exhibit 72, the effect of alternative two is essentially to raise the company's revenue requirement in year three from roughly 91 to 148 million. Do I have those numbers right?
Yes, that's correct.
Okay. So that difference would show up in a larger increase in year three of the MY plan. Is that a fair statement?
Not, and that's probably better for company witness Fiery, but it's not one for one because remember we also had a surcharge. So you're setting a surcharge to zero, right? That used to have a rate effect on customers. So you have to think of it kind of the net effect is going to be a little bit different than this. And of course, I think the other thing I probably should have said this on Rejoiner, so my apologies. This is just one way to do this. We understand that the commission can move some of these tax benefits around, change how some of these are working. So we still advocate for no revenue requirement increase in the first 2 years. We still think it's the right kind of public policy action to take, but fully acknowledge that the commission has discretion as to how it does that.
Okay. Thank you for that, and thank you overall, Mr. Vahos. That's all I have for you.
Great, thank you.
Do any additional parties have examination of the witness? Ms. Sikora, how much redirect do you have?
Actually, I don't have any.
All right. Why don't we take a break now until 11:30 a.m. Then we'll see if the commissioners have questions of the witness. We're in recess.
Great, thank you.
We'll reconvene in approximately 1 minute.
Can you hear me?
No, Commissioner Herman, it's really poor.
Okay, thank you.
In terms of planning the rest of the day, we'll continue through about 1 o'clock and then take a lunch break. The commission is back on the record in case number 9645. Let's see if we're trying to bring back the witness. Mr. Vahos, can you hear me?
Yes, sir, I can. I can hear you and see you.
There you go. We can see you now. We'll begin with commissioner questioning, beginning with Commissioner Herman.
Thank you very much. Good morning, Mr. Vahos. And I'm just going to apologize in advance. They're doing all sorts of drilling and my headphones aren't working. So we're just going to get by as best we can here. Drilling next door. Mr. Vahos, I just have some big picture questions I'd like to ask you. Is BGE asking for a revenue requirement, multi-year plan, or for approval of these various specific projects that are laid out in all of this testimony?
I would happy to answer that question, Your Honor. If I may, just for 1 second, I did want to apologize for, I should have said this at the outset, for chewing gum. It helps with allergies and sniffles and coughing, and I didn't think that was a good thing for the case, so I do apologize for that. In terms of the question, Your Honor, as I understand the MYP implementation order, in my mind, we're asking for approval of base rates, right, that are supported by work that we have demonstrated to be in the customer's interest. I kind of think of it as since the prudency determination in the implementation order is actually happening in the reconciliation process, that you aren't really approving the work per se. I think you're saying, hey, we think this is a reasonable basis based on what we know today to support those base rates. But I read the order as saying you've left yourself that prudency determination on whether that was the right work and whether these rates were appropriate for that reconciliation step.
Okay, thank you very much. And so would you agree that the company's plan is to provide safe and reliable service within the revenue requirements that is approved by the commission?
Absolutely.
Okay, thank you. So, Mr. Vahos, I guess, one of my big questions is here, what is the rate increase in each year of the multi-year plan? And I'm not talking about the rate impact. I'm talking about the rate increase. And if you could point me to where in your testimony it says what the rate increase is.
I'll be happy to do that, Your Honor. The best place to go for the most current version of both electric and gas is rebuttal testimony. And in that, if you'll just forgive me because I have to get to the right page, you'll see that on page 3, it's chart 1. And I'll just wait till you get there, Your Honor.
Okay, I'm there.
So chart 1 has, multiple lines like we always do in finance and accounting world. But if you go to electric as an example, that top line shows you kind of the cumulative revenue requirement over the years, right? So that's the electric 107.7, that's 107 million. That's pre-mitigation, right? So pre-tax benefits, all those other things we've been talking about. Comparable number down below that is the 64 million, 0.6 to 4.8 or 65 on the round for gas. Now, of course, the only difference, Your Honor, is with that alternative, obviously that third year for gas would change in that Exhibit 72 that we walked through this morning. But that's the only other tweak to this. But this is the last version of both electric and gas.
Okay, so you're asking us to approve over $170 million in year one in rate increase. Is that right?
That's correct.
Okay, and have there been any other cases that you're aware where we've approved over $170 million in rates?
The closest one that I can recall, Your Honor, and I can't remember the case number, so I apologize, but there was a case where the commission authorized an increase of about 113 million. I don't know why I can remember the number, but not the case number. But that's probably the closest one I can recall. But I do think this is a little different than your normal historical rate case when you talk about an MYP, especially when we talk about moving from historical to MYP. That transition is pretty significant. So, if you'll bear with me, I hope I can explain this clearly. So the last time we set rates was in 9610. And we used a historical rate case to do that, right? You're very familiar with that. All the commissioners are. So now we're moving to a model where in the year of 21, we're using the budget of 21 plus the activity in 20 plus whatever wasn't captured in 2019 in the last historical rate case. So as you move from a historical model, and that first time you do an MYP, you're really moving forward, and so you have kind of this compounding effect, if you will, that you don't have in a traditional historical rate case where you only look backwards 1 year at a time. Now, it's just so I'm clear, it's just a phenomenon associated with moving from one model to the next. Once you're in that MYP model and you have future MYPs, you won't see that kind of movement again because you're already in that new paradigm. But as we transition, that's exactly what will happen. And it will happen for every company filing an MYP.
Okay, so why do we see a increase of another 154 or more than that, 100 and 200 and then 300 in 23?
Well, these are the cumulative revenue requirements. Maybe it's easier to see it in exhibits, Your Honor. Hold on. Maybe I led you to the wrong place. If I may just have your indulgence for a moment.
This is cumulative. Okay.
Yeah, I'm sorry.
Cumulative.
So, yeah,
all right.
It's not the best place. There's a lot of other exhibits, but there's so many numbers I try to avoid taking people there and confusing them. So I apologize for that.
Okay, sorry. I can see my external noise is setting things off. But all right, so I gave you a preview of this question, Mr. Vahos.
Okay.
How much extra do ratepayers pay for all of these extended amortizations?
So when we talk about like the regulatory assets as an example, so I appreciate the early question. Gives me a chance to do some of the math. So when we talk about the regulatory assets and slowing them down and deferring them, there's actually two pieces to that, if you will, from a revenue requirements perspective. So the net impact, and you can, if I can ask you to go to yet another one of my documents, that's on actually page 4 of my rebuttal. So it's the very next page. You'll see that chart. If you were to add up all the regulatory asset adjustments for electric, so in other words, 31, 12, and 11, and comparably for gas, that's the last line under gas, that 9, that 3, and that 3, you would get a net impact to customers of $69 million. Okay, that's both the reduction in expense, right, or I should say the acceleration of tax benefit back to the customer, offset by the rate base impact because those assets are bigger than they otherwise would have been, right? So the revenue requirement for the rate base effect is $7 million, right? That's the cost of having these reg assets for longer. but it's offset by $76 million of reduced amortization. I said tax expense before, I apologize. Reduced amortization for the regulatory assets.
I'm sorry, I didn't follow you. Try again.
Yep, no worries. I apologize. This is complicated stuff. So if you I'll take a step back again.
Yeah. So what I'm getting at is, you're right. I mean, because because we're collecting it over a longer period of time, and the company is earning its authorized rate of return on that asset. What's the incremental dollars? How much more does it cost customers to recover that asset? It should just be one number, right?
Yep. Yeah. So I just want to make sure it was clear in terms of my testimony that it was the net that we were presenting. So the return, the incremental return of extending the life of the regulatory assets in the MYP through the 3 years of the MYP is $7 million for both electric and gas combined. So that's the effect of taking a 1-year hiatus and then slowing down or extending the lives in the MYP. Hopefully that answers your question, Commissioner.
Okay. And with respect to the AMI asset, that was originally a 15-year amortization, was it not?
That's correct.
Okay. And so if that was 15 years, so now it's going to be a 20-year amortization. Do I have that right?
Rough math, yes.
Isn't the average life, wasn't it anticipated that the average life of those meters were between 10 and 15 years when they were approved?
Yes, absolutely.
So are customers going to be paying for, now we're at 20 years, so customers are going to be paying for meters that have been replaced at, potentially a wholesale fashion?
They could in that hypothetical, Your Honor, they could. I do want to, if I may, so we're proposing an approach for the MYP in the goal of keeping revenue requirements flat for 2 years, right? That was our goal. That doesn't mean that the commission can't revisit the life of these regulatory assets in 2024 in the second MYP. The commission has done that many, many times in many, many cases, change the amortization schedule. So I don't want to make it sound like once you do this, you don't have the option to revisit. What we're done here is try to find ways to mitigate the impacts of the pandemic for our customers and keep revenue requirements flat.
Well, you're not keeping revenue requirements flat. You're keeping the rate impact of the rate increase flat, aren't you?
Yes. The ultimate result of my math is yes, that the rates are flat. That's correct. Obviously, there's revenue requirements impact by definition, but we're offsetting it through these mechanisms. Absolutely.
Right. I want to be really crystal clear that we're talking about rate increases here.
Yes.
And large rate increases.
Yes, Your Honor.
So I'd like to ask you a little bit about STRIDE, and let me see if I have your position correct. That you're suggesting that because if you were to recover all of STRIDE without a surcharge as one of your options, is it possible that you'll be recovering in excess of $2 per month per residential customer?
Is it possible that we would be well, the surcharge is 0 in that hypothetical, so everything would be in base rates?
Right, it's in base rates, but the STRIDE is a statutory program that has a $2 limitation on a residential customer's monthly bill. So it appears to me, and perhaps I have it wrong, that there is at least the potential in 2022 and 2023 for the company to be recovering more than the equivalent of $2 per residential customer.
I understand, Your Honor. Yeah, I don't disagree with that. So I think we view the STRIDE statute, however, as not binding the commission. In other words, it doesn't exclude the commission to explore alternative ways like an MYP to deliver the same policy goal that the STRIDE legislation was originally intending to do, right? That acceleration of gas assets, obviously these days predominantly low pressure gas assets. There's nothing in the bill that says the commission doesn't have the ability to move to an alternative model, on another forward-looking mechanism like an MYP. And so we don't, at least as we read the statute, and again, I'm not an attorney, so please take it for what it's worth, but as we read the statute, there's no conflict here. There's no prohibition for the commission to move and explore new ways to effectuate the same policy goal. And so that's why we're very comfortable that there's no real issue here in terms of either alternative one with our hybrid model or with the alternative where the stride surcharge is set to 0.
So let me give you a hypothetical. If, and I believe your testimony said that you would be in a worse position and it would be a very difficult position for the company if we effectively kept stride the same. So let me give you a hypothetical. Well, let's start with some actuals. What is the 2019 stride actuals that are going into rate base, that you're proposing go into rate?
The 2019, I don't actually have, I don't have that number. I apologize. That's not in my testimony, Your Honor.
Okay, well, we'll see where we land on this one, but I may be asking for that, so we'll see.
Okay.
So let's say we take the 2019 and we roll that into rates, whatever hasn't been recovered of 2019.
Yes.
And
it won't be a big number, Your Honor. Oops, sorry. I apologize. It won't be a large number since we had a case in 9610, so that's why I don't have it readily. I can tell you what the totals were in 19, somewhere in that 150, 160 million, but most of that would have been captured in 9610. I just don't have that piece. I apologize.
Right. So there's a little bit from 19 that wasn't captured in 9610. And what's the number for 2020? Actual.
2020 would be 150, 160 million, rough number for stride.
Around 160.
Sounds right.
And does that include what you expect to finish by the end of the year?
Yeah, that's the 2020 total number. That's correct.
So if the commission then rolls whatever relatively smaller amount from 19 plus the 160 from 20, that would then set, in a normal stride situation, a non-multi-year plan, that would then, you would then set the surcharge at 0 and move forward, would you not?
That's correct.
Right. And so that would mean that in 2021, there would be a surcharge and there would be a certain amount. And then in 2022, the surcharge might go to $2, hypothetically speaking, because you had more investment.
That's correct.
And then it might stay the same for 23. I guess what I'm getting at is the stride statute doesn't assume that you're going to file a rate case every year, does it?
It's silent as far as I recall, Renee. It doesn't presume one way or the other. That's correct.
That's right. So I guess I'm not exactly sure why the company is so much worse off if we just applied stride and assumed, this was just a regular rate case and we waited until you'll have rates in effect starting January 1, 24, from which you could roll the 21, 22, and 23 stride costs in without a concern that you're exceeding the $2 cap that's in the statute.
Yeah, I guess a couple points, Your Honor. Why it's worse is because the MYP comes with a stay out provision. So I am prohibited from taking the normal relief that I would do in a scenario where we have reached the surcharge cap. Keeping in mind that there's no base rate cap, right? But there's this surcharge cap concept. And so in a normal world, prior to the MYP, I would go ahead and be looking forward, seeing when we might approach that point of time for the gas business, and then make a judgment about filing for a change, right? In the MYP world, I don't have that remedy. And therefore, I actually end up undermining stride investments relative to all other investments in the MYP because they're not getting treated the same as all the other MYP assets, right? In terms of the budget sets the rate, the budget sets the rate. And so that's where the harm comes. It's really the stay out provision that precludes me from taking an action. Again, we don't feel there's a conflict here. We really don't see how the stride cap applies because that was a surcharge concept. And we're not talking about a surcharge here in the MYP context. We're talking about a forward-looking model to set base rates. And we continue to believe that the commission has full authority to do that.
You know, Mr. Vahos, you know, that absent a multi-year plan, you've already recovered all of through 2020. So what you're looking at is potentially maybe a 1 to 2 year lag, which seems to me to be somewhat customary in the rate case environment. I mean, there's no guarantee that a company is going to file in every single year, and it was also the company's choice to make this multi-year filing. Wasn't it possible that this could happen when you made this multi-year filing? You made the decision to make it?
You know, Your Honor, we feel very comfortable that the commission has the statutory authority to do what we proposed either in the original filing or the alternative filing. So no, we didn't consider it as some likely scenario that we would be creating a situation where the stride investments would be worse off. I agree with you that in a historical world, you didn't necessarily file every single year. You will find that for the gas business in particular, just given the scale of the acceleration, that is more true that it is almost annual. It's just such a large program relative to the size of the business that it generates a need to come in pretty frequently.
Okay, let's move on. How much of the rate increase is due to contingencies associated with all of these projects? You know, there's lots of discussion about various projects, and some of them have contingency and some of them don't. What's the total amount of contingency in this rate case?
On a revenue requirements basis, it's going to be, if you'll give me 1 second, Your Honor, because I can actually give you a fairly precise sense of what that is. 15. Hopefully that number's here. Well, that would help if I would talk about the number. I did not. Well, you know, without having the exact thing that I need to answer that, it's going to be, let me say it this way. First, importantly, just for the record, we use contingencies very, very sparingly, right? We only use them for IT projects, and it was typically just the larger ones, and then for large infrastructure projects. The vast majority of our budget has zero contingency in it, okay? In terms of and I'm just trying to remember, I can't remember the exact number, but in terms of the O&M related IT contingencies, it's like in the single digits in terms of like millions of dollars. And then in terms of the capital contingencies, I want to say it's somewhere in and this is capital, not revenue requirement, is like 10 million, depending on the year, 10, I think actually 20 has the largest, if I recall, maybe like 15. So if you were rough Vahos math here, or rate making on the fly math, if you were trying to convert those two things, it's effectively going to be the IT O&M is really your revenue requirement proxy. So it's going to be in the less than 10 million range in any given year.
Okay, thank you.
Mm-hmm.
Mr. Chairman, that's all I have for right now. I'm going to go through my notes as everybody else, as the other commissioners are asking questions, and see if I have other questions.
Thank you, Commissioner. We'll turn to Commissioner O'Donnell.
Thank you, Mr. Chairman. I have, I think, 3 question lines for you.
Yes, sir.
One is, I guess I'll continue the conversation around STRIDE. So STRIDE is a program created by the legislature in statute that allows advanced recovery for improving aging infrastructure in the gas sector, right?
Yeah, it supports the acceleration of asset replacement for the gas business. Yes, sir.
Right, through an advanced recovery mechanism. In other words, you can start recovering through that surcharge before an approved project is used and useful. Correct?
Yeah, I call it more contemporaneously, but yes, I understand what you're saying. Yes, sir.
So up until you reach at least up until you reach the $2 cap, and then it may be more contemporaneous for sure, and even more, maybe more retrospective. But that's how it was designed, right? The legislature said can't impact a customer by more than $2 for this advanced recovery mechanism.
For the surcharge, that is correct.
Right. And that you have to wait until the next base rate case to get the rest of your investments back in what you have an obligation to do anyway, which is provide safe and reliable service as a function of your franchise. Is that not correct?
Oh, absolutely. We absolutely have that obligation.
Okay. So help me understand why your suggestion of setting the surcharge to 0 isn't a bypass around the statutory limitation on the impact on the average residential customer.
Great question, Your Honor. So in our view, as we read the statutory framework and that cap, which applies to a surcharge, it doesn't prohibit you as a bench from saying, we're going to explore a new alternative way that was not contemplated in that statute or that part of the statute to get to the same result. And so that's what this MYP is, right? It's another forward-looking kind of mechanism that uses budgets to set base rates. So when we look at the STRIDE statute, it doesn't tell you can't, as a commission, explore new ways to set base rates, and that's what we're doing in this proceeding. And therefore, the STRIDE surcharge cap doesn't apply because this is a new model you've created that wasn't even contemplated at the time that the statute was passed back in, I guess it was 2012. So that's how we read the statutory framework. We rely on the intent of the General Assembly to create a framework that is really supporting that accelerated basis of changing these assets out. I think the commission has been fantastic in supporting that, so we appreciate that. But as we look at the language, and again, I'm not an attorney, so but just bear with me. As we look at that language in the context of an MYP, which is new, we don't see any prohibition on you including gas infrastructure investments into base rates for purposes of an MYP.
So then let me approach the question that I'm wrestling with from this angle. As the company implemented its tariffs out of the number 9610 rate case, the surcharge was set to 0, right? As you discussed with Commissioner Herman, and then you started accumulating projects under the surcharge. And what did you say it was today approximately?
Oh, the current rate for STRIDE? I actually don't know that answer, Your Honor. I apologize. So
no problem. Is it under 2 or is it capped?
It's under 2.
Under 2.
Yes, sir.
Okay.
Yeah.
So even to this day, the impact on an average residential customer for STRIDE since 2019 and the exit from case 9610 to today has been under the statutory cap, and so the ratepayers haven't been impacted. Now, assume arguendo that we approve your proposal for STRIDE, setting the surcharge to 0, and we allow you to proceed with that. When does the impact on the ratepayer go above $2?
Just for the STRIDE investments. I think the Commissioner Herman, I think, captured that correctly, and it's in the testimony. The revenue requirements that equate to that would be effectively at the tail end of 21 and then all of 23.
Okay, so let's go then to your Exhibit 72, if we could.
Sure.
So in 2023, the revenue requirement will be $148 million, right?
The total for all of gas. That's correct.
Yeah. And how much of that will be the stride that you just referred to, the stride impact?
Your Honor, if you go down 3 lines, you'll see it's 57.
Okay. So how much does that $57 million, how much of an impact is that to the average residential ratepayer?
Oh, for gas, that is actually a question I can't answer. I'm sorry, Your Honor. It's just not something I've studied, so I don't have a basis to give you a good number, even an estimated one, unfortunately.
Would it be fair to assume, and I think you discussed this with, that it's significantly more than $2?
I'm sorry, just for the 57? Because I think this is all, I guess what's confusing me, this is all of gas. It's not just stride when you talk about the 148.
Right, but you said the 57 million was stride. We went down 3 lines or 2 lines.
Correct.
Is that more than $2 on the average rate impact on the average ratepayer?
In that single year, in theory, just the 57? Yes. Yes.
Yeah.
I see what your question. Yes.
Probably significantly more.
Yeah.
And isn't that violative of what the intent of the legislature was, to limit the impact of $2 a year for stride recovery?
I think the limit, well, I can't speak for the legislator, obviously, Your Honor, because I'm not one. But yeah, again, I read the statute as saying, and we believe it's a surcharge prohibition to go above $2 before you have to take, some action in stride today. We don't see that prohibition extending to an MYP, Your Honor. I think that's the difference, is we don't see any prohibition of this commission doing what we're proposing to do in the MYP.
Let me ask you this: for the 3-year rate effective period for the MYP, is there any advanced recovery for stride approved projects? Any at all?
Any advanced approved?
In other words, are you recovering on stride projects before they become used and useful in any way, shape, or form anywhere in the 3-year rate effective period?
Yes, it would behave very similar to today.
So it behaves like a surcharge.
It does in that
It's
sense.
not called a surcharge.
Yeah.
It's a surcharge by any other name, right?
I think the difference, Your Honor, is it's base rates. It's not a surcharge.
I get it, but on the impact on the customer, it's advanced recovery that the legislature has limited that impact to $2, and you're getting around it, I think.
Yeah, we just don't see that prohibition in place, Your Honor, with all due respect. I'm not dismissive of the questions the commission has raised. I don't mean it that way, but we thought about this carefully. We thought about the statutory construct before we made this filing, and we wouldn't have proposed something that we didn't believe this commission had the authority to do under the PUC article, and that's still our belief today. But again, I'm not dismissive of the questions that the bench has raised today.
Thank you. Let me switch gears a little bit. Can we go back to it was page 36 of your rebuttal?
Just give me a moment. Yes, sir, I'm there.
In lines 5 through 10, you were discussing with Ms. Cora on a live rejoinder, I believe, about that passage there, and you talk about in line 6 having one of the lowest ROEs in the nation. Can you substantiate that for me?
Oh, yes, sir. Thank you for that clarification. I did not mean to suggest that the commission has awarded one of the lowest in the nation. No, what I was trying to convey is that the Office of People's Counsel is recommending one of the lowest in the nation. So I apologize for the confusion.
So BGE does not have one of the lowest ROEs in the nation, correct?
That is correct, sir.
And
Absolutely correct.
And your current ROE is a result of a settlement agreement in case number 9610 that the company agreed to.
That is correct, Your Honor.
Okay.
Sorry for the confusion. So apologize.
No problem. So you're talking about the Office of People's Counsel's suggested ROE.
Yes.
But that's not reality.
That is not reality.
Okay, fair enough. I wanted to clarify that because I wasn't sure what you were saying there.
No, I'm glad you did. I sure as heck don't want to leave the wrong impression, Your Honor.
There are enough trade publications that criticize our awarding of ROEs. I didn't want to see it written.
Yeah, we don't want to add more fuel to the fire, Your Honor. I agree with you.
Okay. So one last line on the ROE performance adder, and you referenced my question yesterday. And today, I think you said, and correct me if I'm wrong, that you don't necessarily expect the performance adder to be approved by the commission necessarily, and that in case 9030, you referenced one, there was a similar situation where one was asked for and the commission dealt with it by giving due consideration in the ROE itself and not approving the performance adder. And so I have to ask this. This is not an easy question to ask, but I'm going to ask it anyway. Was this performance adder put in here to influence the commission's decision, ultimate decision on our ROE, as you suggest was done in 9030? You seem to be alluding that you want it to be an influencer on our ultimate decision on the ROE.
Yeah, I think we came at it as we're setting an ROE for 3 years under an MYP that does not get reset. There's no true up. It's frozen, right? And you don't revisit ROEs again under the implementation order until 2024, right, under the MYP. So as we were thinking about this, it was really more of and again, this is a policy decision for the bench, Your Honor, obviously. But we were thinking about if we're going to move forward to a new paradigm, this is the time to advocate for a situation where we recognize top quartile, top decile performance in the adjudication and in the ultimate ROE that it's awarded. It didn't feel appropriate to wait till 2024 to us because it's kind of a policy decision that should be made now. I'll be the first to admit that given that the pandemic is still going strong, remember we filed way back in the spring, that the notion that the commission could award some kind of discrete adder at this point is I get why that is probably not going to happen, and I understand the rationale for that. So I was just defaulting to we've asked the commission in its past in case number 9036 originally for a discrete adder, and in that particular case, it was a gas only case. It made a judgment that we're not going to do that as a matter of policy in Maryland, but that we will consider performance as we judge where within the range of reasonableness our company's ROE should be set.
And wouldn't that more appropriately be addressed, as I was discussing yesterday, in the other proceeding that we're developing right now with performance incentive mechanisms that help us carry out state policy, discrete state policy? Wouldn't that better be addressed there? And you're a stakeholder in that process.
Yeah, Your Honor, I don't disagree that that's another avenue to try to deliver a similar kind of outcome. We were very conscientious of the fact that the PIM proceeding was still ongoing. We were very hesitant to run basically in front of the commission and file some kind of proposal that would look or feel like a PIM when this bench hadn't had an opportunity to rule on how those things should be structured. So it was a conscious decision on our part to say we can't do that in fairness to a bench that's still trying to think through and make a judgment in that arena. But we still felt as a matter of policy, we had to raise this issue of how do we recognize really good performance in the context of an ROA.
Okay, fair enough. Well, you're not suggesting that the commission ought to be influenced in its determination of a just and reasonable ROE by the addition of this adder, even though you don't expect it to get approved. You're not suggesting that,
right?
All right. Thank you. Thank you, Mr. Chairman.
Any additional questions from commissioners? Commissioner Richard.
Thank you, Mr. Chairman. Good morning, Mr. Vahos.
Good morning.
Just a couple of questions. A lot has already been covered, but first I was interested in your testimony. I believe this is your rebuttal, where you comment on gradualism and the recommendation of Mr. McAuliffe. And you note that the reductions of 35 basis points for electric and 20 basis points, and you go on results in something less than gradual. But if we look at your current ROEs and your recommendation to go to 10.1% ROE, I mean, that's puts you in the same kind of range, right? An increase of 30 basis points and 20 basis points respectively. Is that gradual, or I'm just trying to understand how what staff McAuliffe is recommending isn't gradual, but what you're requesting is gradual.
I think that's a fair observation that I think the relative movement is the same, Your Honor. So I think that's a good question to ask us. And so, again, I think it goes back to our belief that some form of recognition of performance is appropriate from a policy perspective. I understand, as I told Commissioner O'Donnell, right, I don't believe a discrete adder. And 10-1 is likely in my future for this rate case outcome. But I do have concerns, and I thought company witness McKenzie did a wonderful job yesterday of setting up. Hey, you're talking about an MYP that is completely new, that no one's ever actually gone through the entire process. There's a lot of uncertainty. And I think Commissioner O'Donnell yesterday, asked about gradualism. So in my mind, I guess I wouldn't see a big move from my current rate. I don't think that's in the best interest of the company. I don't think that's the best interest of this MYP process. And so that's really where I was thinking about gradualism. And when I see an ROE of 9.4, that's not a great place to be. I think that makes me very uncomfortable. I think, company witness McKenzie yesterday talked about 9.5. Staff also supports 9.6. I can see something in that scale. I would prefer to stay where I am because I think we're a top quartile performer, and hopefully the commission will take that into account. But that's where my mind is when we talk about.
Okay, I understand. So you don't see it as ungradual or contrary to the commission's relying on the principle of gradualism.
I don't, Your Honor.
Okay. All right, thank you. Also on page 22, you discuss the cost of debt and reject staff, Commissioner Staff McAuliffe, recalculation of the cost of debt in this proceeding. And I also note that there's no proposal to adjust at all the capital structure at all. Can you tell me how, or if the company is looking at these historically low rates currently for ways that would benefit the customer in your operations at all? If you are, can you tell me specifically where and how you are looking at these and using these historically low rates to, on behalf of the customers?
Absolutely, Your Honor. So let me tackle the first question first, if I may, kind of the cost of debt phenomenon. There was a misunderstanding on my part when we prepared my direct testimony originally. I thought the cost of debt was also frozen. When you go back and read the plain language of the implementation order, in fact, it's only the ROE and the cap structure that's frozen. So that was my misreading of your order. So when I realized my mistake, that made me quite honestly feel much more comfortable with the staff's proposal to take the average of what we had proposed in the budget, take a look at what the current forward curves look like, create an average for the cost of debt, because we have a model where no one wins or loses, right? We're going to relook at the actual cost of debt by the time we get to the reconciliation. So I think that's perfectly fine. I think in terms of the actions we've taken, Your Honor, I'll just point to what we did here in 2020. Originally, again, I want to thank the commission. You were great in the early part of this year. You moved in an accelerated manner to approve my debt application so I could go ahead and access the capital markets in a timely manner. We actually took a debt transaction that we originally contemplated to do in September of this year, and we accelerated it into June, Your Honor, and we actually increased it. So from 300 million to 400 million, and we got the lowest rates we've ever gotten. So you're going to see us continue to do that, to take every opportunity. We'll move the size, we'll move the issuance dates, we'll look at the size of debt that we're going to issue to maximize the savings that we can get for customers.
Great. The last question just involves, I guess, shared services among all the utilities. And it's one of those areas of savings. Does that primarily happen through Exelon's business services company?
Yes, for the most part. Things like payroll is a great example. That's one we can all understand, or accounts payable. Those functions are sitting in the BSC organization, and we all leverage them across the enterprise.
Okay, and is that the primary way that you can realize these sort of group benefits?
It's definitely the largest, Your Honor. Yes.
The largest. Okay. Yeah. And on page 69, you talk a little bit about the BSC category. Talk about, it's two main areas: one IT, and the other is non-IT, and that includes things like corporate and information security services, corporate affairs, corporate development, executive services, Exelon Utilities, human resources, legal, real estate, risk, and supply, and I think elsewhere it kind of gets into more detail.
Yes, sir.
So, how much did you have control over those costs? And let me just tell you where I'm going with this. I'm looking at the deferred prosecution agreement and the $200 million that over the next several years that Exelon has agreed to pay. Looking at categories like this, how can we be assured that, in fact, and those costs are not going to be passed along in any way to the ratepayers in BGE's service territory? Because a lot of these areas that are described look very close to the areas that were involved in the scandal.
No, absolutely fair question, Your Honor. So one, I answered the first part of that question, kind of the controls. We have very rigorous controls around how we recognize costs and where those costs are distributed. So that's not a new thing. In terms of the deferred action agreement, I can give you 100% certainty because I've asked directly to make sure that none of those costs are going to be coming to Maryland in any shape, way, or form. Those are going to stay, I don't know if they're staying corporately or they're getting charged to some other affiliate. That's not my concern if it's charged to ComEd or not, where those events happen. But in the case of Maryland and our customers, they will pay zero for that deferred action agreement.
Okay, so nothing you're pretty certain nothing will get kind of folded into the service company at all. And you mentioned that there are other areas. Can you reassure customers of BGE that there aren't any other places where these costs could be slipped in any way?
Yeah, no, I can absolutely give you 100% assurance, Your Honor, that the costs associated with a deferred action agreement are not going to be pushed down to the BGE company and therefore its customers in any shape, way, or form.
Okay, and then just finally, I thank you for these reassurances. I think that they're important. And then some of the underlying activities, those costs, are customers protected from, again, payments, to other companies to influence, and are you certain that those are also well stripped out of any of these costs that could come through, like the BSE or any other mechanism? in the company?
Yes, Your Honor. I'm very confident we have vigorous controls to make sure that the services that are being rendered are actually services that the utility needs, and to the extent that you have costs as you described, that they're not being distributed to some other company like BGE who's not taking the service. So I have no concerns whatsoever in that regard.
Great. Well, thank you very much for your answers, and thank you, Mr. Chairman.
Thank you.
Thank you, Commissioner. We will go to Commissioner Linton.
Thank you, Mr. Chairman, and good afternoon, Mr. Vahos.
Good afternoon.
Just a couple of questions for you. Mostly tied around the adjustment 38, the accumulated deferred income tax regulatory liability. Could you refresh my memory, or perhaps if it's in the testimony somewhere, direct me to the total liability amount? Is it the 287 million, or is there a larger number than that?
You said, pardon me, Your Honor, you said 38. Yeah, I would think of it as we have basically used it all. So yes, it's effectively I'll call it the non-protected. There are other protected assets that you may recall. So therefore they have to, from an IRS perspective, follow a particular life. But for the non-protected properties and for the Maryland subtraction modification, we've effectively used, if not all of them, almost all of them in this proceeding.
Okay, so as we all know, there's an election ongoing right now. And there have been a number of different tax-related policies that have been floating around from both sides of the aisle. If next year, for example, or during the course of the MYP, there's a change in the corporate tax rate, what impact will that have on the MYP as it's pending for customers if it happens between now and 2023?
There's two events that occur, if I may, Your Honor. So the first one is I'll say the additional instant expense, for lack of a better word, in the scenario where you go from a corporate rate of 21 to, let's say, 28. You would instantly have higher tax expense that would need to be recognized, right? And that would happen whenever that statute from the federal government became effective. Okay. The other dimension is you would have the opposite effect of what happened with tax reform. Instead of having a regulatory liability because customers have overpaid taxes, right, theoretically, since the rate came down, you're going to have a regulatory asset because now customers have underpaid in theory. And that one, ideally, I would have the ability to create a regulatory asset, but that one you don't have to deal with immediately. So you don't have to instantly say, at least for the non-protected property, I'll have to think about what happens to protected property, but at least for the non-protected property, the commission would have full discretion to think about what's the right time to deal with that kind of an item. So like I said, there's two impacts. There's the immediate expense impact of whatever tax or benefit if it were to go down in that hypothetical. And then there's this issue of now the customers are out of balance, right, in terms of what they paid relative to what they should have paid. Hopefully that's
so
clear.
Do you think, for purposes of using MYPs, for example, would the commission, in your opinion, have set any kind of precedent or standard by using all of the liability in this MYP, and would the company then expect the return of the regulatory asset in the event taxes go up within the next year?
No, Your Honor, no. I don't see any precedential value for how the commission would determine what the appropriate value is for any kind of regulatory asset in that hypothetical. I think these are pretty unique circumstances. I think the commission will recall that we had advocated for originally longer lives, right, to kind of spread out the benefits over time. It really was the pandemic and the desire to keep customer rates flat for 2 years that caused us to revisit the lives. In the absence of a pandemic, I don't think we would have done anything of this scale for the MYP. So I don't see, it's really in my mind more, in other words, facts and circumstances based that in this instance, we're trying to react to a health and economic event. And I don't see how that could be used to say, well, you should give us an equally accelerated recovery on a very narrow time frame in a hypothetical where we have a reg asset.
Okay, so if this liability didn't exist, and I'm thinking more along the lines of the lessons learned component of this pilot NYP initiative. We won't have $287 million available for the next rate cases that the utility company files. So what types of lessons learned are we gaining from this rate case that's going to help us in the next one when we've got access to this large pot of funds that won't be there to assist the next time? Do you think are we skewing the lessons a bit? Is there a way we should manage our expectation for what the next rate case will look like?
I think the good news is, Your Honor, and I think I was describing this to Commissioner Herman, this one is a little bit weird in this first MYP because we're going from historical to budget based. So you have a bigger effect as a consequence of, I'm going to call it catching up effectively. You won't have that problem in the second MYP, right, for any company that chooses to file one, right? You will already be at the right cadence. So by definition, the impacts are just going to naturally be a little smaller than they were in this adjudication. And then I think one of the benefits that the Commission outlined in its implementation order, if I remember correctly, is when we're looking at 3 years at a time, we have a little bit of flexibility as you think about kind of rate impact by year, right, in terms of how you shape things. So I think that lesson learned we've seen here, right? The company actually is the party that took action to try to shape rates, right, to reach an objective, i.e. keep rates low for 2 years. And I think that kind of multi-year view allows similar kind of discourse and even decision-making by the bench.
Okay. All right. Thank you, Mr. Vahos. That's all the questions I had. Thank you, Mr. Chairman.
We'll return to Commissioner Herman.
Thank you, Mr. Chairman. Mr. Vahos, a couple more questions. Is it the company's view that there should be no regulatory lag whatsoever?
That should be no regulatory lag whatsoever. I think the company's view is that this MYP provides us with an important improvement in terms of reaching all the benefits, not just regulatory lag. I think if I go back to that kind of cash working capital discussion that we had earlier, where I'm saying if we take cash working capital out of rate base, we end up creating a little bit of regulatory lag, right? And so if that's the Commission's policy decision, I think that's fine in the context of an MYP and making your own judgment about what's in the public interest standard. I think if you're really going to achieve all the benefits, we should consider including it as an example, right? So we get predictability, transparency into the plans. We have predictability for customers, we have a little bit of ability to smooth out things from a rate perspective, and we have regulatory lag improved.
Okay, thank you. The tax benefits you were talking about with Commissioner Linton, that's really ratepayers' money that they paid and that you're paying back sooner, right?
Yes, ma'am.
Is there a cost associated with paying it back sooner? Cost to ratepayers associated with that?
It's going to be the similar kind of phenomenon as the regulatory assets, Your Honor. To the extent that they had a longer life, then they would have had the effect of keeping rate base lower, which means your return on rate base would have been lower. So it's, in that sense, it's true for even the reg asset. There's kind of a time value of money concept here, right? If it's sitting in rate base, then it's going to either earn a return, or in the case of a liability, reduce the return that's earned. Or if we accelerate getting it back, then the customer's got the cash now, but rate base is bigger. So if you think about it in terms of the time value of money, you're kind of indifferent because of the way the rate making model works. But yes, just in that scenario where we compare an acceleration of flowing back these benefits to customers versus one where we follow the original lives, then yes, rate base is bigger than it otherwise would have been, which means revenue requirement associated with rate base is slightly larger.
Right. Well, you gave me a dollar figure of $7 million associated with the added cost of the reg asset extended amortizations. Is there a dollar figure associated with the accelerated tax benefits?
There is, Your Honor. anticipated that question might come up. So that number for the MYP is for both electric and gas about 45 million in terms of that revenue requirement for rate base.
$45 million.
Yes.
Okay, so that's customers would have received $45 million more if you hadn't accelerated it.
Yes, in terms of lower return on rate base, yes. Yeah, the absence of a return, yes. And that's the cumulative number for all 3 years, Your Honor, for both electric and gas.
Okay, thanks very much. So do you know the impact of the rate increase just on the distribution portion of the bill in 2023? Do you know that?
I don't. That's a question for company witness Fiery, Your Honor. It's just not something I'm really familiar with.
Okay, I thought that was the case, but so I guess part of my question, Mr. Vahos, is again another big picture question. You know, part of the multi-year benefit of a multi-year plan was that we have rate increases that are gradual, right? And so here you're offsetting. We have rate increases here. They're being offset, and then we're looking at it. I believe for a residential gas and electric company customer, it's 8% on their total bill. So it's going to be a big jump on a distribution portion of the bill. So how does that meet that goal of the multi-year plan to have gradual increases instead of large step increases?
Yeah, that's a great question, Your Honor. We really did struggle with what's the right answer from a policy perspective. I think I mentioned this a little earlier, but in the end, it's really the commission's decision. We landed on in the near term, it was more valuable to customers given both the health crisis and the economic impacts of that health crisis to go ahead and build an MYP that kept rates low for the first 2 years, fully acknowledging that that third year is bigger than we would have liked had we not had to deal with the pandemic. But it was an intentional way. I shouldn't say intentional. It was our best effort to try to find a middle ground for customers who need some kind of certainty around price, and ideally price that's staying at zero. I think the commission has full authority that if 23's impact is too large, you can shape how some of these tax benefits have been modeled and have an increase like in 22 as an example, right? And that would indeed mitigate what happens in 2023. But again, hopefully the bench will appreciate we were just trying to find the best middle ground that we thought would meet what customers needed.
Yeah, I understand. So if the commission were to move some of these dollars around, this $287 million tax benefit around, is there anything we need to be concerned with or anything we need to take into account as we were going to do that, if we were going to do that?
No, Your Honor. So in the case of that lever or the regulatory assets and their life and schedules, there is no like IRS problem as an example. So we did not touch the protected property. This is all items that you have full discretion to move as you deem proper and in the public interest, and there's no issues whatsoever. The other thing I'll mention as a lever is all of these numbers are predicated on the 10-1 ROE, right? And so obviously, as much as I would love to see a 10-1 ROE, I realize that's probably not going to happen. And so that's another level that you're going to naturally have as you think about how you shape these revenue requirements and ultimately rates.
Okay. Thank you very much, Mr. Vahos. I appreciate your testimony.
Thank you.
Commissioner O'Donnell.
Thank you, Mr. Chairman. I'll try to be brief. Mr. Vahos, I wanted to follow up a little bit more on Stride, if you'll indulge me. And maybe this is Ms. Fiery's bailiwick, but I'll ask you first, and then if it's hers, she'll be prepared. Explain to me the hybrid nature of your original proposal of Stride one more time, please.
Absolutely, Your Honor. So what we envisioned in the original filing proposal, not the alternative, was a world where you would effectively have a hybrid. You would recover Stride assets in the surcharge up until that time when you effectively hit that $2 cap. Okay, so that would be late 2021. And then all the assets after that would be in the MYP base rates. So there's no double recovery, right? It's just some of those investments are getting into the Stride surcharge. Some of those investments are getting into the later years of the MYP base rates.
Okay,
that was the
so
original proposal.
Similar to our discussion of the $57 million on your exhibit 72 that I think we agreed would exceed $2 per average customer. Even your original plan will exceed $2 per customer in late 2021.
If you're thinking about it in the context of the surcharge, yes.
Yes.
True, yes.
Okay. All right. Thank you. I just wanted to clarify that. Thank you, Mr. Chairman.
Do any of the parties wish to question the witness based on the resulting answers from the commissioners?
Your Honor, I do have a few redirect questions, if you don't mind.
Proceed.
Okay. Mr. Vahos, still following up on the Stride surcharge. Currently right now, how, if you can guess, a residential customer, how much would you say is in their bill currently for Stride?
Oh, in their total bill?
Yes.
It's definitely going to be north of $2 for sure because of all the Stride investments we've made since the program started.
Okay, so in total, even though, you know, the surcharge might be less than $2, it's the total bill is going to have all the surcharges that have been moved in.
Oh yes, it'll be multiples of $2. Of that I have no doubt saying.
Okay. And so any way we were to structure this, customers are going to have more than $2 in their bill in total.
Yes.
Also, still, Commissioner O'Donnell asked you about accelerated recovery under our Stride proposal. Currently, when you put, strike that, let me rethink this. Under normal rate making, historical test year rate making, investments get into rate base when they go in service, right?
Yes.
Is that changing in the MYP? I mean, other than the fact that instead of when they actually go into service, it's going to be when we estimate, our best estimate of when they're going to go into service.
No, your characterization is correct. That really the mechanics of how things get into rates is the same. It's just a function of one is a budget, and then in historical rate cases, it's actuals.
So then, and would Stride be the same way?
Yes.
So then it's really not accelerated under the MYP?
I think that's a fair characterization. It's really no different than before.
Okay. So it's when the assets go into service, the Stride assets, they will go into rate base.
Correct.
Or at least when we estimate that they're going to go in.
Good clarification, yes.
Okay. Thank you, Your Honor. That's all.
All right. Thank you, Mr. Vahos. You are excused.
Thank you.
We will take a lunch recess now and return at 1:30 p.m. We'll go off the record. I'll have some instructions though. So we are off the record. So we have one witness left, Ms. Fiery for the company. We're moving expeditiously today. We'll, after Ms. Fiery, we'll take the two Department of Defense witnesses. I recognize that the Amtrak and Walmart witnesses are not present today, as well as the Maryland Energy Group witness. So Office of People's Counsel, there is a possibility that we actually may move to your witnesses later this afternoon. So just please be prepared for that.
We believe they are ready. We will confirm that over the lunch break.
Thank you. We'll see everybody back at 1:30 p.m. We are in recess. The commission will resume in approximately 1 minute. Commission is back on the record in case number 9645. Counsel for BGE, you may call your next witness.
Yes, Commissioners, BGE calls Ms. Lyn K to the stand.
Good afternoon, Ms. Fiery. If you could please raise your right hand and wait for instructions from the court reporter.
Do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
Ms. Fiery, can you speak up? Oh, we cannot hear you.
Uh-oh. She's having a similar problem, I believe, as Mr. Oh, not received.
We'll go off the record and have this resolved.
Excuse me, Mr. Chairman. Ms. Sikora, is your witness going to be logging back in from a different location?
Oh, looks like she just did.
Excellent, thank you.
Ms. Fiery, can you hear us now?
I can hear you. Can you hear me?
Yes.
Oh,
okay, good. All better.
Okay. All right, we'll go back on the record and wait for the court reporter to swear you.
Okay. Do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
I do.
Okay. Good afternoon, Ms. Fiery. Could you please state your full name, employer, and position for the record?
Yes, I'm Lyn K. Fiery. I'm the manager of rate administration with Baltimore Gas and Electric.
Okay. Ms. Fiery, do you have before you a document entitled The Prepared Direct Testimony of Lyn K. Fiery, dated May 15th, 2020, consisting of 46 pages and 5 exhibits?
I do.
Your Honor, this document has been pre-marked as BG Exhibit 28. Ms. Fiery, do you have before you a document entitled The Prepared Rebuttal Testimony of Lyn K. Fiery, dated September 11th, 2020, consisting of 35 pages and 2 exhibits?
I do.
Okay. Your Honor, this document has been pre-marked as BGE Exhibit 29. Okay, and finally, Ms. Fiery, do you have before you a document entitled The Prepared Surrebuttal Testimony of Lyn K. Fiery, dated October 7th, 2020, consisting of 3 pages and no exhibits?
I do.
Okay. This document has been pre-marked as BG Exhibit 30. Were these 3 documents prepared by you or under your direction and supervision?
They were.
Do you have any changes or corrections that you need to make to any of these documents?
I do not.
If I were to ask you the same questions in each of these 3 documents today under oath, would your answers be the same as those written in the testimony?
Yes.
Your Honor, at this time, I would move that BG Exhibits 28, 29, and 30 be entered into evidence.
No objection. Exhibits 28, 29, and 30 are moved into evidence.
Okay, and Your Honor, just some very brief rejoinder for Ms. Fiery.
You may proceed.
Thank you. Ms. Fiery, were you watching the hearing on Tuesday when Mr. Case talked about the alternative stride recovery proposal under the MYP?
Yes, I was.
And like Mr. Vahos, you probably heard Mr. Case say that you'd be preparing an exhibit and talking about it when you came to the stand?
Yes.
Your Honor, I'd like to turn to BG Exhibit 73. That was sent to the commissioners and the parties yesterday morning, along with the exhibit Mr. Vahos talked about this earlier today.
Yes, we have those exhibits, that exhibit.
Okay. Ms. Fiery, can you please talk about the results of your bill impact analysis of the alternate stride proposal?
Sure. The exhibit includes a bill comparison of what the monthly bill impact is for the company's rebuttal position as compared to the alternative stride method that witness Case and witness Vahos testified to in these hearings. And as you can see from the first page, for the residential customer class, in year 1, customers would see a decrease in their monthly bill of $1.03. In year 2, a decrease of $2, and then in year 3, an increase of $2.88. And I believe, Commissioner O'Donnell, you had asked Mr. Vahos about what the bill impact would be of the 57 million differential, and that's what this exhibit is showing. And you can see over the course of the 3-year period, the net impact on customers in terms of monthly bill is close to 0. There is a small difference, and that's just due to the differences due to the nature of the stride surcharge being a fixed monthly charge and base distribution rates being volumetric.
Okay. Thank you. Ms. Fiery, staff witnesses Hauer, Thompson, or Harris, and Hoppeck have each filed surrebuttal testimony that states that there will be different imbalances for each class as a result of the MYP reconciliation process. What is your response to their assertion? And I'll add, Mr. Counsel for Staff Spivak also asked about this of Mr. Vahos earlier today, and Mr. Vahos said that you'd be able to address this question.
Yes, I have reviewed the surrebuttal testimonies of the staff witnesses you mentioned, and I don't fully understand how the reconciliation process would result in different over/under recoveries for the different customer classes. What BGE has proposed in this case is to do the reconciliation by line of business, which is consistent with how the Commission illustrated the reconciliation process in their order on the MYP pilot. The reconciliation, as staff seems to be describing it, was not documented that way in the PC51 workgroup report. And based on my understandings of the discussions that occurred in the PC51 working group, it was not how it was discussed in the workgroup meetings. The reconciliation that, again, based on my understanding, was discussed in the workgroup is what's set forth in Appendix 1 of the Commission order on the MYP. And it's clear from my review of that appendix that the reconciliation is by line of business, not customer class. I've proposed that the reconciliation, that any imbalance resulting from the reconciliation be allocated to customer classes based on their proportion of revenues at the end of MYP year 3. And this means that the imbalance will effectively be allocated in the same manner that it would have been had the revenue requirement been based on actuals from the start. But however, because I don't fully understand how staff is envisioning the reconciliation process to work, and the fact that we have ample time before the company is required to file a reconciliation in this proceeding, I think it might be more appropriate for the Commission to direct the company to work with staff and any other interested stakeholders on the reconciliation and the allocation of a reconciliation imbalance. To the extent it's deemed appropriate in those discussions, the language that staff has taken issue with in my proposed tariff filing could be removed from the proposed tariff at that time.
Thank you. Your Honor, that's all the rejoinder I have for Ms. Fiery. At this time, I would ask that BG Exhibit 73 be moved into the record.
Hearing no objection, BG Exhibit 73 is moved into evidence.
The witnesses, oh, sorry.
We'll begin the cross-examination by the counsel for Walmart.
Great, thank you, Your Honor. Good afternoon, Ms. Fiery.
Good afternoon.
My name is Barry Naum. I represent Walmart in this case, and I would just like to ask you a few questions regarding the company's proposed rate design for Schedule GL, which you sponsor in this case. Could you turn to your rebuttal testimony, which is Exhibit 29, and turn to page 19, please.
Okay, I'm there.
On lines 14 through 19, you discuss Walmart witness Cronauer's recommendation to accept BG&E's proposed customer charges at the requested revenue level, but to then allocate 100% of remaining revenues to the demand charge component. And if I understand your testimony correctly, you disagree with Mr. Cronauer's proposal to recover the remainder of the increase through the demand charge. And this is based upon your concern with gradualism. Is that correct?
That's correct.
And also, if I understand the company's rate design, your proposal does move some costs in increasing amounts from the delivery charge to the demand charge. It just doesn't go as far as Walmart has recommended. Is that accurate?
That's accurate. I do support moving a larger percentage into the demand charge as compared to the delivery service charge.
Okay, great. And so in lines 4 to 5 on the same page, you state that Walmart witness Cronauer believes the company could go further to improve the rate design for Schedule. So based on that sentence and what you just testified, I understand that you believe that the rate could be improved further. Is that fair?
Than where it is today, yes. Mm-hmm.
And even where it is under the company's multi-year rate plan proposal.
Yeah, I think to the extent the Commission would like to increase the demand charge at a greater rate, there certainly are causative reasons to do so, as supported by the cost of service study presented by company witness O'Neill.
Great, thank you. So again, and I don't want to be repetitive, but it sounds like you agree in principle that all things being equal, putting aside gradualism for just a minute, you do agree that collecting demand-related costs through energy charges generally violates cost of service principles.
That's correct.
And you also agree then that all things being equal, gradualism aside for just a minute, that recovering demand-related costs through delivery charges can have the effect of introducing or exacerbating subsidies within a rate class. Is that fair?
That's correct.
And that could be based upon load factor.
Yes.
So that by shifting demand-related costs from lower load factor customers through the delivery charge, you're increasing costs to higher load factor customers. Is that fair?
Yes, that's correct.
And so you agree that those intra-class subsidies exist today in the company's rate GL structure?
Yes, they do.
And you would agree that those subsidies would continue to exist under the company's proposal in this proceeding?
Yes, they would be reduced through my proposal, but they would not be completely eliminated.
Yes, thank you. And I certainly don't want to ignore your concerns regarding grad. So if we could maybe talk about that real briefly, excuse me, could go to the next page, page 20 of your rebuttal testimony.
Okay.
On lines 11 through 13, you state that the company's approach to allocating this greater increase in demand charges for Schedule GL is consistent with the accepted rate design in a number of previous rate cases, and you list a few of those there. If I'm not mistaken, you've been with the company since 2013, is that correct?
That's correct, yes.
Were you involved in any of these rate cases that you mentioned on page 20?
I was involved in cases number 9610 and 9484, which are not listed on this page.
I see. Okay, thank you. But you're familiar with each of these cases by reason of testifying to them in your rebuttal testimony, correct?
Correct.
On those lines, where you say that allocating a greater increase to the demand charge for Schedule GL is consistent with that cost-based approach, are you referring to what we just discussed, the company's attempt to move more of the demand-related costs into the demand charge?
Yes, that's what I'm referring to, is that the commission had accepted a rate design where a larger proportion of the revenue requirement was allocated to the demand charge as opposed to the delivery service charge.
And so in terms of gradualism, it's your testimony that the proposal in this case is just yet another step in that process that the company believes is appropriate.
Correct.
And if you look at that list of cases that you've included, it looks like case number 9230, 9230 was a 2010 rate case. Does that sound approximately right to you?
Yes, that sounds right.
So it's fair to say that the company has been pursuing this cost causation rate design for Schedule GL for about a decade.
That's correct. Mm-hmm.
So by extension, the company has also been using the principle of gradualism for about a decade, correct?
I would, subject to check, I would agree. I obviously was not involved, as I said, in these cases personally.
Sure.
That's my understanding.
No, thank you. That's fair. Given that the parties in the commission in this case are considering a 3-year multi-year rate plan, we're looking at the extension of this policy of gradualism for at least another 3 years, correct?
Correct.
And that could extend beyond those 3 years, depending upon when BGE files its next rate case or multi-year plan, correct?
Right. I believe there is a requirement for the company to file its next rate case before the end of the MYP period.
Okay, that's good. Thank you. But to the extent that any intra-class subsidies currently exist in the rate structure, we are asking those customers to continue paying those subsidies for at least another 3 years. Is that right?
That's correct. Mm-hmm.
Ms. Fiery, is there a point in your opinion, just your opinion, of when we can say that gradualism has served its course?
I don't know if I can really pick a point in time where I would be able to say that. I think there is still quite a bit of way to go in terms of getting towards full parity for the GL class in terms of the right cost being recovered through the demand charge. So I don't think I can really say when that point in time would be.
Okay, great. Thank you. Appreciate your testimony. Your Honor, that's all I have for this witness.
We'll turn to cross-examination by counsel for Maryland Office of People's Counsel.
Office of People's Counsel has no questions for Ms. Fiery.
We'll turn to counsel for Maryland Public Service Commission staff.
Good afternoon, Ms. Fiery.
Good afternoon.
Before we start, I just want to make sure we're using the same terminology. When you use the term delivery service charge, which one of the types of rates are you referring to?
The volumetric base distribution rate.
Thank you. So, Ms. Fiery, did you calculate the percent increase you're proposing for Schedule SL's delivery charge when you did your testimony?
Yes, I did.
And would you accept, subject to check, that it's over 276%?
We need to stop for a second. The court reporter, can we open her mic? Linda?
I really could not understand the last two answers.
Okay.
They were all garbled.
Yeah. Ms. Garofalo, we continue to have a problem with your microphone picking up lots of noise. And when the witness is responding, we're going to need your microphone off. So either Ms. Fiery or Ms. Garofalo, one of you need to be on mute at all times. Okay.
Okay, so it says mute.
Ms. Garofalo, I believe your mute button is reversed for some reason. I think when it says mute, you're unmuted and vice versa. Can you hit your space bar for a moment? There you go. Okay, so your space bar will mute and unmute you. You're currently live.
Okay, and I did not get the answer to your first question, Ms. Garofalo.
Okay, so why don't I just start again, because it's fairly simple.
Okay.
Ms. Fiery, just to be sure we're using the same terminology, when you use the term delivery service charge, what type of rate are you referring to?
I'm referring to the base distribution rate that's volumetric and based on energy use.
Thank you. Ms. Fiery, did you calculate the percent increase you're proposing for Schedule SL's delivery charge before you filed that in your rebuttal exhibit? It's exhibit LKF-2.
Yes, we did.
Would you accept, subject to check, that the rate increase you're proposing for that class is in excess of 276%?
For the delivery service charge, yes, not for the rate class overall.
Wouldn't that be the largest rate that they would be paying?
Not necessarily. So they are charged the delivery service charge, and then they also, to the extent that they use company-owned lighting fixtures, they're charged a per fixture rate as well, and they're just done on different measures. One is a volumetric rate based on consumption, and one is per fixture. So it's hard to say that it's the largest rate that they're paying. I don't think that's necessarily true.
Well, I'm really going, I picked them because they were the most egregious, but I really wanted to find out how that position adhered to the principle of gradualism. And you had some questions about that from Mr. Noem just a minute ago, and so maybe you could help me on that.
Are you asking about the principle of gradualism in relation to the delivery service charge for Schedule SL?
Correct. In response to a delivery, in regard to a delivery service charge in excess of 276%.
Yes, so the company has proposed that a large percentage of the increase allocated to Schedule SL be allocated to the delivery service charge. And that's because Schedule SL saw two fairly significant reductions in their rates, as did the other classes, from the Tax Cut and Jobs Act and the nuclear decommissioning costs being removed from base rates. And in both of those reductions, the company removed those revenues from the delivery service charge alone. We didn't change the fixture rental rates. So over the course of those two reductions, there was a reduction of about, I think, 2.6 million, subject to check, in revenues just from the delivery service charge. So my proposal in this case is to allocate what gets to, I believe, subject to check, about 2.2 million in revenues back into the delivery service charge, to get the charge closer to the level it was before those two reductions that I mentioned. And that's trying to get the overall rate design of the class back to the way it was before the reductions were taken.
Just so I understand, you're trying to undo the effect of removing the nuclear decommissioning rates and the effect of the Tax Cut and Job Acts from the street lighting class.
Not to undo the effect, but to get the class back to the rate design, the different proportions of revenue that were recovered from each element of their rate design back to the level it was before those reductions were taken.
So this is something that would show up in the URORs for the classes, correct? Whether or not you've accomplished that goal.
No, because even if you allocated less of the increase to the delivery service charge, that would mean it would go into the fixture charges. So the UROR of the class would remain the same, whether you accepted my proposal to allocate 85% of the revenue increase to the delivery service charge, or if you accepted a lesser percentage, for example, we'd still end up in the same UROR place.
Well, I don't want to spend too much time on this, but it does sound to me as if that means that the fact that there's a separate charge for fixtures really doesn't affect what's happening to the street lighting class.
It does, and you can see it in my my e-sheets. You can see that what goes into the total base distribution revenue for the street lighting class includes both delivery service charge revenues and fixture rental rates. Both are components, just like for Schedule GL, which we were just discussing. There's the customer charge element, the delivery service charge, and the demand charge. It's similar to that, except it's delivery service charge and fixture rental rates.
Okay, well, I'd like to talk to you a little bit about your rebuttal testimony. You proposed something, and tell me if I'm wrong. I believe this came out of something that OPC witness Efron proposed. Am I correct?
I believe it was, yeah, witness Efron and witness Hoppick had some testimony as well.
Yes. Do you remember what witness Hoppick said? If you don't, I can help you out.
I believe a subject to check, he recommended or stated that the company would need to adjust the forecast for sales if Efron's proposal was accepted. I think you're muted.
Thank you. So I think in fact, I know that what Mr. Hoppick said was that Mr. Efron's proposal, which he put forth as an accounting adjustment, was actually not an accounting adjustment, and that if Mr. Efron's proposal were accepted, I believe he at least implied that rates would need to be adjusted. Does that sound like, does that sound correct to you?
I think so. I believe he was addressing it through the billing determinants need to be updated, but yeah, subject to check. I think that's the general idea. You're muted again.
No.
You're good. You're good.
Now you can hear me. Okay. So I'm not sure if this is part of your proposal or if one would have to read past your rebuttal testimony. So maybe you could just help me out with this. To the extent you're proposing that billing determinants would be updated, would that include all billing determinants for 2002 and 2003, but not 2001 and not the bridge year?
That's correct. And I would just say it's not necessarily my proposal. It's just we wouldn't be opposed to doing a billing determinant update if that's something the commission was interested in. For rate design purposes, we would be updating the billing determinants for 2022 and 2023. And that's really just due to the fact that there wouldn't be enough time to update billing determinants for 2021 because we'd be getting an order in this case at the end or in December 2020.
Let's just follow that a little bit. So for the 2 years when you would be updating something, I'm jumping way ahead here, but at what point during the billing year would such an update be able to occur?
I believe what I said in my rebuttal testimony was that we would propose to update billing determinants for rate design purposes along with the project list filing in November. So for the update for 2022, we would file updated billing determinants for rates and resulting rates in November of 2021 to take effect January 1, 2022.
So that would be your proposal, but what would happen at that point? Would these automatically go into effect?
No, we wouldn't be able to charge the rates to customers without approval from the commission through, I imagine, the administrative hearing process. But we would have to propose tariff sheets with modifications to our rates as part of that as well.
Would other parties to this proceeding be able to do discovery on what you propose or make any filings? Would there be time for that? I'll rephrase that. Would there be time? How much time would they have before these rates would have to go into effect?
Well, as I said, it would be what we've kind of outlined is it could be the billing determinant update could be filed in November for rates effective January 1. So that's about 2 months, a little less than 2 months would be the amount of time.
Thank you. Now, I think you've already indicated that you're familiar with Order 89482. This is the order that governs the MRP?
Yes, that's correct.
Does that order provide for updating billing determinant forecasts during the pendency of the MYP?
Not to my knowledge.
Would you agree that billing determinants, and in the case of an MRP, forecasted billing determinants impact BGE's requested revenue requirement, whether it's a traditional case or a forecasted case?
you're asking if forecasted billing determinants impact the revenue requirement? Is that the question?
The question is, do billing determinants have an effect on the revenue requirement?
So I think that would actually have been a better question for company witness Vahos. I'm really not the revenue requirement expert. Sorry, we can't hear you.
Let me rephrase it, because I think company witness Vahos referred something similar to you. So you're the last witness. So I'm going to have to re-ask the question, but I'll reword it a little bit. In this case, which is a multi-year rate case using forecasted numbers, which result in a revenue requirement based on forecasts. So I'm calling that a forecasted revenue requirement. If the billing determinants are revised after the end of this proceeding, would that revision result in a change in rates?
So to the extent the commission was interested in the company updating billing determinants for rate making and rate design throughout the MYP proceeding, then yes, it would modify the rates, but it would not modify the revenue requirement, to my knowledge. It would just be a billing determinant update for the purpose of setting rates charged to customers.
Could rates increase under this procedure?
They could go up or they could go down. I have no way of knowing which way that would go, but it would be the same revenue that BGE would be authorized to collect. That would not change. It would just be the rates charged to customers.
But the amount a customer would have to pay each month for the same level of service could go up.
Yes, it could change. Yeah.
In response to Mr. Naum's questioning, you talked about using lines of businesses rather than class costs of service. I'm not sure I followed that, and because since we're setting rates and we do that based on rate classes, I just hope you could explain that.
So I think you're referring to my rejoinder that I did at the beginning, where I talked about the reconciliation process through this MYP period and how staff witnesses Hoppick, Hauer, and Thompson have stated in their testimonies that they see the potential for different classes to have different imbalances. And my response to that was that the company has read the MYP order and interpreted the Appendix 1 that the Commission included in that order to be a reconciliation by line of business. And my recommendation from that rejoinder was that the Commission direct the company to work with staff and any other interested parties to sort out how the allocation of the imbalance would work, because we have time before the first one would be filed, because I just don't fully understand what they're envisioning, and I don't think it has to be decided today, like through these hearings, since we do have time.
Could you perhaps just refer us, you don't have to do it from the stand, to exactly what you're talking about and where in the order that is? Just a paragraph number or two is fine.
So I don't know the paragraph number, but there's a Appendix 1 to the commission order is an illustration of the reconciliation. And that's where I'm saying to me, it's clear that it's at line of business, by line of business, not for each individual rate class.
So when you did several sets of testimony in this case, and when you proposed rates, were they by rate class or line of business?
They are by rate class. The revenue requirement is allocated to each rate class.
Could you describe the allocation method that you're proposing under Rider 15 and 16?
Yes, under Rider 15 and 16, as I stated earlier in my rejoinder testimony, is it will be allocated based on the proportion of each class's revenue at the end of MYP year 3. That's how the imbalance will be allocated to the classes under my proposal.
Does that mean there would be no reconciliation prior to that?
There would be a reconciliation that results in the imbalance, and then I would take that imbalance and allocate it to the customer classes. So the reconciliation is happening first, looking at the actual cost and the actual distribution revenues and other revenues that the company has collected over the course of the MYP period.
Right. Now you're aware that under certain conditions in an MRP, and this would be something you would be determining or discovering or working with during the reconciliation, the commission may determine that revenue should be returned to customers.
That's correct. If an imbalance is an over collection, if you will, it would be returned to customers. Yes.
Now, am I correct that the purpose of Rider 15 and Rider 16 are each intended to govern those returns?
That's correct.
And if there's an overcollection of revenue that the commission determined should be returned to customers through Rider 15 or Rider 16, according to the proposed language, how would that return be allocated?
It would be allocated to the customer classes based on each class's proportion of revenue at the end of MYP year 3.
Is that the same way you did your, you set your rates in your various testimonies in this case?
It gets to the same end result, yes, because after my two-step allocation method, each customer class is left with an amount of distribution revenue that they're paying. So my proposal to allocate the imbalance is just to look at that proportion that each class ends up with after my rate design. So effectively, it would get to the same place that I've proposed in this case for the forecasted revenue requirements.
But it's not the same, correct?
Effectively, it is the same without, I don't think you would go through the same first step, second step with an imbalance. That's not typically how we allocate imbalances for other true-up type mechanisms.
I guess all I'm trying to get to is this where the line of business that you talked about with Mr. Naum comes in?
So again, I don't think I was talking line of business with him. I think that was in my rejoinder. But by line of business, I just mean electric versus gas, and that the company would be doing a reconciliation for electric and then a reconciliation for gas. That's what I'm saying when I say line of business.
So maybe an example would help me out here, because I think I've gotten a little bit confused. So if in year 2, BGE's the commission finds there's been an overcollection that should be returned to customers. Can you tell me how the customer classes would be treated?
So if there was an overcollection that the commission deemed should be given back to customers, under my proposal, let's say that overcollection was for electric only, my proposal would look at the MYP year 3 ending revenues by each class and allocate the imbalance based on the proportion of total revenues that each class has at the end of the MYP period.
So I think you just told me you're going to allocate based on class.
Yes, the reconciliation will be performed and an imbalance will be derived from that reconciliation for the electric line of business. And then I will take that imbalance and allocate it to the customer classes based on proportion of revenues at the end of MYP year 3.
Thank you, Ms. Fire. I have no further questions.
Do additional parties question this witness? Ms. Sikora, do you have any redirect?
No, Your Honor, I don't.
Do commissioners have questions of Ms. Fiery? Seeing none. Thank you, Ms. Fire. Oh, I see hands now. Commissioner Herman.
Sorry. Good afternoon, Ms. Fiery. How are you today?
Good, how are you?
Good, thanks. So my first question that you might have anticipated, because I've asked a number of people this question, what's the distribution, if you just look at the distribution bill, what's the increase and percent of distribution bill increase?
Yes, for MYP year 3 for electric, it's 13%, and for gas, it's 15%.
15%. Okay, thank you.
Mm-hmm.
Now, I wanted to ask you a little bit. I was wondering why I'm looking at page 19 of your direct.
Okay, I'm there.
If you're asking the commission to approve a $9 customer charge, why didn't you change the customer charge in years 1 and 2?
Yep, so I think under a normal MYP where we didn't have the COVID pandemic going on, we would have proposed gradual movement over the course of the MYP period over the 3 years. But in this case, we thought it was important to maintain certainty for customers when it comes to their bill. And as I've shown in the exhibits to my direct testimony, I think it's LKF1, really kind of based on usage, low users, high users, they're fairly indifferent to my proposal in terms of bill impact, but we didn't want to have a bill impact for the low users, the extremely low users, by introducing a customer charge increase in year 1 or year 2, because that could affect the bill of certain customers depending on their level of usage.
So I guess I saw that, and I'll ask you a little bit about LKF1 in a minute, but it just occurred to me, what, as a BGE customer, which I am, my bill in 2021 would not change. The rate I'm being charged won't change. Is that right? The kilowatt hour rate and the customer charge rate, nothing's going to change?
The rate will change slightly just because in the distribution charge, the actual rate printed on the bill is also the company's Rider 10 mechanism and Rider 25, which Rider 10 is the administrative adjustment where we are giving back the commodity related expenses, and Rider 25 is decoupling. So that will naturally change the distribution charge, but the revenues that we're receiving from distribution customers won't change over the course of that period.
So isn't that a little deceiving to customers? I mean, if you think about it, because customers think I'm paying the same rate, but in fact they're paying $107 million more, and we're hiding that from customers for 3 years that they're paying that.
Yeah, I don't think they're not based on my understanding, it's not they're paying $107 million more. The decoupling mechanism is just mitigating for the impacts of different factors like weather or, yeah.
You misunderstand
Okay.
me. I'm talking about in Mr. Vahos's testimony. Sorry, if these books are big, it takes me a while to get there. On page, I think it's page three.
Of his rebuttal testimony? Or
is it his rebuttal?
Or direct?
I think his direct, but
okay.
His second direct, part 2.
Okay.
Right. So it's well, it's 100. I think it's 107 in the SIR rebuttal, but it doesn't matter for purposes of the question. It's 100 and incremental revenue requirement before benefits and adjustments is $109 million, right? That's more than customers are currently paying. How are customers going to see that they're paying that their rates are higher?
So yeah, so their rates won't be higher in year one because of the benefits that we've used to shield them from that impact, I guess, in years 1 and 2. But they will be able to see what their rates are going to be in 2023 in the tariff that I proposed. All 3 years of rates are going to be shown on the tariff, so customers will have that transparency of what's to come in the future. I don't know if that really answers your question.
I'm sorry. Go ahead.
Nope. Go ahead. Nope. You're good.
Are the customers going to see on the tariff sheet, and it's been a while since I looked back that far, is it showing them that they have this offset, this tax offset and all sorts of offsets that are effectively offsetting the rate increase?
No, they would not see that there are offsets. They would just see the same rate that they're charged now in year 1, year 2, and then year 3, a different rate.
Now, you may not be the right, this has just occurred to me, so you may, and I apologize, but you may not be the right person, and that's okay, because I think I have the right to recall a witness if I really need to. If the commission were to determine that these offsets the rate increase and the accompanying offset needed to be transparent to the customer, is that something that could go on the bill?
I think we do. We have, based on my understanding, we have the ability to put messages on bills, but I am probably not the person to be able to speak to exactly what that could look like.
Yeah, and I'm not exactly sure who would be,
yeah.
frankly. But I might, I'd like to make that a bench data request, because I have a feeling that there isn't necessarily, nobody's talked about,
right.
There aren't any witnesses who are really, bill formatting type questions. And so I'm wondering if the commission desired to have customers understand that the rate is going up, but that there are offsets being applied to that rate. If that were something the commission wanted to do, is that possible, and what would it look like? I don't have to have a bill mock-up or anything like that, but just give me an idea of what that might look like, if you can.
Okay.
Okay. Yes. Thank you. Okay. Looking at LKF1, which you referred to.
Okay. Yep. I'm there.
Okay. So you cited in your testimony the 92%, which is based on example D, the average, right?
That's right. Yes.
Okay. So even if somebody uses a whole lot less, this example shows that even a customer that uses a very small amount of electricity, it's not going to make a measurable difference. It's in terms of variable, it's 84 versus 85%, right? Do I have that right?
Yes, with or without the customer charge. Yes, that's correct.
Okay. And then you go down and it's identical
Mhm.
The variable percent is identical if you use 75%, right?
Correct.
And then looking at C, it's again, 1 percentage point off.
Yes,
Right.
that's right.
Okay. Let me see if there's anything else I had for you, Ms. Fury. That's all I had. Thank you very much. Appreciate it.
Commissioner O'Donnell.
Thank you, Mr. Chairman. Good afternoon, Ms. Berry.
Good afternoon.
Page 40, going over to 41 and then 42 of your direct testimony, you talk about the stride surcharge. And you heard my discussion with Mr. Vahos and Ms. Sakura's rejoinder following that question. So I want to ask just some questions.
Okay.
They describe a process where the projects don't go into base rates until the project is completed. Do you agree with that?
Again, I'm not really the revenue requirement expert, but I believe that is what they were conveying, yes.
Okay. How does that happen in the rate? You mean you're the manager of the rates. So how does that happen? Say a bunch of projects complete in July of 2021. They complete in July of 2021. So before that, they're not in rates, and then after that, they are in the process, as I understand they were describing. How does that work?
Are you asking in the context of the stride surcharge or base rates in general?
All right, let's just start with stride surcharge. Is it an automatic increase in the surcharge in July, or?
So again, I'm not really the revenue requirement expert. What my team does and what I kind of oversee is we receive the revenue requirement and determine how to set rates based on that revenue requirement. But based on my understanding of how that works, the company will file in November of each year a project list and a plan for stride, which includes the planned work that we plan to get done in the following year. And that's where we include assumptions about when we expect projects to go into service. So that's how it flows into the revenue requirement to go into rates. So it's not that in July we will automatically increase the stride surcharge because that project went into service. It's handled through that project list filing and revenue requirement at that point in time. And then, of course, there's a true-up mechanism associated with the surcharge.
Okay, so let's go in a different scenario. Now we're capped out at $2 on the surcharge. So we're not talking about the surcharge. Those $2 is already met, and that project completes in July. How does it go into rates? How do ratepayers start paying for that project all of a sudden before July, because it wasn't complete, they weren't paying for it? How does that happen?
So under the company's proposal for the multi-year plan framework, that would be included in MYP rate base and our assumptions for what we need for each year of the plan. I don't know if that's really answering your question, but.
Well, then wouldn't you have to start collecting that revenue at the beginning of the year? Because it's not going to change through the course of the year, right?
So I believe, yes, but I think that's consistent with how the stride surcharge is done now as well. I don't think there's a difference there, but again, not really the revenue requirement expert.
Yeah, so I guess what I'm struggling with here, and this is new to all of us, of course, we're all going to learn from this, and that's part of the reason we have this pilot. And so that's good news. But what I'm struggling with is we used to have to wait, and your testimony says so, wait until the next rate case before projects are brought into rate base from stride.
That's correct, under the old.
But now we're going to do it in the confines of a multi-year rate case, and that's why I'm struggling so much. How does that automatically? What is the mechanism that automatically moves that as soon as that project is completed and becomes used and useful? It goes into rates. I'm struggling with that mightily.
Yeah, and I think I'm probably not the best one to give a really good detailed answer just because I'm not that involved in the revenue requirement development. But I don't know that I see much of a difference between the way the stride surcharge is set, where we are looking at our project list ahead of time, and the way we're setting the MYP rates, where we're, again, looking kind of at what we expect to do ahead of time and when we expect it to go into service.
Well, your company's modified proposal is to zero out the surcharge and just add these things in as you go along. And I'm trying to figure out how that works. And that is very different than what we do now. Very, very different. Because right now we wait till the next rate case.
Right. Yeah, I think it's a different framework, and a forward-looking framework versus the historical rate case approach. But I think, as company witness Vahos testified to, I think the company's position is that it's within the statute to be able to do it this way. But
thank you, ma'am. I maybe some of the other witnesses from some of the other parties will be able to help me with my thinking on that. So I appreciate your answers. Thank you, Mr. Chairman.
Richard.
Thank you, Mr. Chairman. Good afternoon, Ms. Fiery.
Good afternoon.
I wasn't planning to ask questions, but since my favorite topic of customer charge came up, I just want to ask a couple questions there.
Okay.
Just quickly, would you agree that in, I guess, most competitive industry businesses, they price on more of a per unit of the product? Is that kind of standard what you expect when you go shopping?
I'm sorry, I missed the last part of your question there.
When you go shopping, don't you expect that for the most part, most businesses, they charge based on the per unit of the product, by product? Not, in other words, the fixed charge. I'm sorry, I didn't start with the fixed charge. The fixed charge is priced in the per unit. Is that correct?
Yeah, I think many industries are set that way. Yep.
Yeah, fixed cost, great. Why is it the utility? Why are you proposing to not act like most competitive industries?
And put everything in a fixed charge, or everything that's the cost of
well, in other words, you charge separately for the fixed charges and then another, volumetric for the variable costs.
So we try through the cost of service study, we figure out kind of what our costs are caused by, whether it's the fixed, like, per customer type of cost,
right,
or with customers actually using energy, or the demand they put on the system. So we try to frame our rates based on that framework and what the actual costs are caused by. So I would say that that's why we don't put everything into a fixed customer charge.
Volumetric charge.
Right.
Okay. Okay, so that's different than most competitive businesses. Is that correct?
Yes.
Yeah, that correct. Okay.
So.
Now, you've just discussed a moment ago that does introduce a degree of unfairness to some customers. Is that correct? I mean, you're holding off a couple of years with the increase in the fixed charge. I'm sorry, the customer charge for 2 years. Because
right.
There's a degree of unfairness to certain customers. So those you mentioned low income, but that would also possibly be like apartment dwellers. They are low consumers. There's also, people who heat their homes with electric or gas. They could probably also experience some of this unfairness.
Are you saying from my proposed $1 increase that there would be unfairness to those customers?
Talking about just the customer charge
in general. Okay, yeah. So the customer charge.
Stop. I would ask that there be no crosstalk. Please wait for the question to be asked, and for the questioner, please allow the witness to answer. Thank you.
So for the customer charge, I guess I would say that there are intra-class subsidies that exist when the costs that we have to establish a customer or set up a customer account are not recovered through a fixed charge. If they're recovered through a volumetric charge, there are subsidies within the class where certain customers are paying for their unfair share, if you will. So that's why the company is proposing, in this case and historically, to move towards cost of service supported levels for our various elements of our rate design.
Okay, so there's there is some unfairness in doing it this way because of the interclass differences between the customers. So what when we looked at, and there were some questions about LKF1. In this case, we're just talking about $1. So we're just kind of making it just a little less fair. Is that right? I mean, if we were to get rid of the entire customer charge, there would be quite a bit more fairness. And as far as the percentages you put down on your exhibit.
That's correct. If we are just proposing a $1 increase to the customer charge, but if we were to increase the customer charge to the levels supported by the cost of service study, that would eliminate those intra-class subsidies or that unfairness that you are speaking of. We're just moving towards that in this case.
Well, no, you would be increasing it, wouldn't you? Because the low user customer will be paying a greater percentage of the fixed costs.
But right now, so based on the cost of service study presented by the company witnesses, O'Neill and Manuel, the customer charge should be at a pretty significantly higher level than it is today, and getting to that level is actually what would reduce the unfairness or the subsidies. So we're making movement to try to reduce that unfairness, because right now the higher users are subsidizing lower users.
Okay, I'm not kind of following that because, you know, a lot of, again, other research that are concerned about customer charges talk about the fact that lower people who consume less electricity are subsidized, are paying a bigger percentage of their bill and toward fixed charges, which is what is unfair about this customer charge.
Point of clarification, Commissioner Richard, are you referring to residential customers or all customers?
I'm talking about the residential class, yes.
Okay, I think the witness may have been confused.
Yeah, I'm sorry. I thought I said in intra class. So yeah.
Yeah, I apologize. I was speaking about the residential class as well, but maybe I was not clear.
Okay, well, that's one area of concern that people raise, of course, is that people who use less electricity, when there's a fixed customer, when there's a customer charge, they pay a greater percentage of the fixed cost. Another area I think in Maryland we're concerned would be on energy efficiency programs. Mm-hmm. The control people have over their bill. Right now, as according to your chart, which table was it? Anyway, the table indicated that there's 98%. I'm sorry, 92% versus 8%. That means there's 8% of a customer's bill that they don't have control over. They're going to pay that whether they can, put an LED light bulb in or not.
That's correct. Yes.
Okay. And so doesn't that run counter to Maryland goals of trying to encourage people to use less electricity?
So I would argue that customers are still receiving the price signal to conserve and to seek out energy efficiency measures because 92% of their bill is volumetric under my proposal and under current rates. My proposal doesn't change the proportion that's recovered under variable charges versus fixed charges for the average residential user. So I would say that customers still have enough of a price signal to conserve since such a great percentage of their bill is still volumetric.
Okay, and I get what your point is. I mean, just going up $1 isn't maybe going to change by itself customers' behavior, but I think we're talking about the concept of customer charges, and at this point we're talking about taking it to $9. So that'll be $9 that all the energy efficiency programs that we may have and empower, it doesn't matter. The customer will not be able to control that portion of their consumption.
That's
that true?
correct.
Okay.
Yes.
So, I mean, so again, by degree, it just seems like, I mean, in a couple weeks, we're going to have Empower hearings, and we're going to be discussing measures that just, are meant to nudge people, a little bit. I mean, here we have something that is a major disincentive to save. And then also for renewables, that's an important, particularly trying to encourage customers to install solar. Let's just talk about solar. Don't customer charges disincentivize that?
I'm not sure that they do disincentivize solar because again, a very large proportion of the bill is volumetric, that 92%. So I would say that there's still plenty of incentive to install solar based on current rate design and my proposed rate design.
Okay. But again, net metering, the idea is we're pricing electricity such so that there is an advantage to installing solar. And so doesn't the customer charge, I mean, that's mandated by the legislature. So doesn't BGE's fixed charge or his customer charge really just sort of blunting the effect of the legislature's initiative to encourage usage of solar and to install solar?
If the witness could answer.
Yep, I would say that the company is trying to balance those state policy goals as well as reducing the intra-class subsidies, as I mentioned, by moving classes rate elements more towards the levels supported by the cost of service study. And that's why we've proposed a dollar increase in this case, which we see as gradual and a small increase that just moves them in the right direction, but doesn't contradict or harm any of those state policy goals that you mentioned.
Okay, well, I understand your use of the word balance, but it still seems like it's an offset to what the legislature intended by through net metering. And wouldn't there be another remedy for the company to take if they were concerned, again, about maybe the impact of solar on the rates?
I'm not sure what other measures or what really to respond with that. I don't know what other measures we would take just in the context of really this case and customer charges in general.
Okay, I was thinking in some states, companies have gone to their legislatures and said, hey, this is, all this solar is having an impact on our cost of service studies. So we would like to, suggest there be there be a charge just for solar users.
Oh,
so,
understood.
Is that something, I mean, has the company gone to, thought to go to legislature and suggest that?
I'm probably not the one to really speak to that, to our legislative strategy or things like that. So I really don't have an answer to that question about what the company has been pursuing or not pursuing.
Okay, fair enough. So, but I think we have established, I mean, there is an impact of customer charges on adoption of renewable energy, specifically solar. Through basically an offsetter of the net metering.
Now the commissioner is testifying. Is there a question for the witness?
I just asked it in a question. There is, is there an impact?
I would argue just based on my exhibit, the LKF1, for the average user, the same proportion of their bill is from the 92% is volumetric rate driven under current rates and also under my proposed customer charge increase. So I would say that there really isn't an impact for the average user for net metered customers, as you mentioned.
Okay. All right, that's all I'll ask. Thank you very much.
Mm-hmm.
Any additional questions from commissioners? Ms. Sikora, any redirect?
No, Your Honor, no redirect for this witness.
Thank you. And sorry, I should have asked, do any of the parties have questions based on the commissioner's questions?
Mr. Chairman, if you could indulge me, I just have a couple of quick follow-up questions.
Yes, sir. And if you could refer to the commissioner who made the question.
Yes, it was Commissioner Richard. Ms. Fiery?
Yes.
You just had a conversation with Commissioner Richard regarding the concept of customer charges. I wanted to ask a couple of questions just for clarification in case there might be some confusion. The conversation was centered around the concern over customer charges for residential rates. Would you agree, based on generally speaking, the largest commercial and industrial customers do not share the same concerns regarding customer charges, and specifically that those customers generally favor fully cost allocated customer charges?
In my experience, and again, not really able to speak for our customers, but it does seem to be the case from the rate cases that I've been involved in and where customers have entered appearances.
Great, thank you. That's all I have, Mr. Chairman. Thank you.
Any other parties? Hearing none, the witness is excused. Does the company have any additional witnesses to sponsor?
No, Your Honor, that concludes our case.
Thank you. Let's just take a brief 5-minute pause. Mr. McNutt, are you ready to present the Department of Defense's?
Mr. Chairman, assuming that Mr. Gorman is able to get his video going, he has been on the call today. So yes, I've just communicated with him and with Mr. Walters. So I think we're ready to go, assuming we don't have any technical problems, but I seem to be communicating okay. I hope Mr. Gorman will as well.
Let's reconvene at 2:52.
John, can you hear me?
Yeah, Mike, I can hear you, and so can everybody else.
Okay, very good. Just testing my microphone.
Okay. Yeah, I can see you. Looks great.
We'll be back on the record in 1 minute. All right, we're back on the record. Mr. McNutt, I can already tell that you have a very sensitive and powerful microphone, so just be mindful of that going forward. You may call your first witness.
Mr. Chairman, the Department of Defense calls Michael Gorman to testify.
Good afternoon.
Good afternoon. If you could please raise your right hand and wait for instructions from the court reporter.
And affirm under the penalties of perjury that the testimony you're about to give and the matter now pending is the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. McNutt, you may proceed.
Mr. Gorman, by whom are you employed and in what position?
Employed by Brubaker and Associates as a regulatory and economic consultant.
And are you the same Michael Gorman who sponsored direct testimony and supporting exhibits filed in this proceeding on August 14th, 2020, and marked for identification in this evidentiary hearing as Department of Defense Exhibit Number 1?
I am.
And was that direct testimony and accompanying exhibits prepared by you or under your supervision and control?
Yes.
And are you the same Michael Gorman who sponsored surrebuttal testimony filed on October 7th, 2020, and marked for identification in this evidentiary hearing as Department of Defense Exhibit Number 4?
I am.
And have you prepared revisions to pages 3 and 4 of your direct testimony? And are those revisions the revisions that have been marked in this evidentiary hearing as Department of Defense Exhibit Number 6?
Yes.
Other than the revisions marked as Department of Defense Exhibit Number 6, at this time, do you have any other changes, corrections, deletions, or additions that you would like to make to any of the direct testimony, surrebuttal testimony, supporting exhibits, or responses to information requests that you have sponsored in this proceeding?
I do not.
Mr. Chairman, DOD moves DOD Exhibits 1, 4, and 6 into evidence.
Hearing no objection, DOD 1, 4, and 6 are moved into evidence.
And I would make the witness available for cross-examination.
Cross-examination will begin with the company.
Your Honor, I just have one question on that. In a number of our recent cases, given the burden of proof, BGE has gone last on cross of the parties. And I wanted to see if we could continue that.
Was that your only question for this witness or just a request of me?
That was a question for you on the order of cross.
Typically, I have staff cross last, but I will accommodate your request.
We're happy to go either second to last or last.
Why don't we do that? We'll have staff follow you. We'll begin the cross of Mr. Gorman with Office of People's Counsel.
We'll make this easy. Office of People's Counsel has no questions for Mr. Gorman.
Thank you, Ms. Ryan. Mr. Corse, the company's up.
Actually, that would be me, and the company has no cross either.
The question may have been academic then. We'll move to counsel for PXD staff.
Yes, I have just a little for you, Mr. Gorman. How are distribution mains currently allocated in BGE's gas cost of service study? And you might think of this as account 376.
They are allocated on the basis of demand.
I apologize. I couldn't hear you.
The small distribution mains are allocated in the company's class cost of service study on the basis of demand.
And does the commission have a practice with regard to how account 376 is handled?
I believe the company has used the commission normal practice or for the allocation of those distribution main costs. However, I took issue with that and request the commission to reconsider the cost causation nature of small distribution mains, and ask that they, for the next case, investigate whether or not it's more appropriate to allocate those costs by functionalizing them both as demand related and customer related, consistent with the NARUC manual, and revising the company's cost of service study in its next rate case.
And can I take from this that you're not aware of any exceptions the commission has made in regard to this category?
I believe the commission has investigated the appropriateness of the change that I'm proposing in this for this utility. I'm not aware of them actually making the change at this point, but I do think it's an important cost of service characteristic that is worthy of the commission receiving adequate information in the next rate case so they can make an informed decision.
Thank you, Mr. Gorman. I have no more questions.
Any redirect, Mr. McNutt?
No, Your Honor, I'm content.
Any questions from the commissioners? Commissioner O'Donnell.
Just very quickly, Mr. Gorman, what assumptions do you make about inflation as opposed to the assumptions in the case?
The assumptions I make are out over the forecast period. I believe it's more appropriate to use a consensus of independent economists' projections of future levels of inflation and use those to project the company's cost of service over the 3 multi-year rate period. In contrast, the company is using its own inflation projection, which overstates independent consensus economists' outlooks for future inflation.
And what are those two respective assumptions on what are the figures, do you know?
The company's, I believe, was 2.4%, and my inflation outlook based on independent economists is 2%.
And what change will that have on the, what impact if we went from 2.4 to 2 in the projection have on the cost of service projection revenues?
That's shown at page 11 of my direct testimony in table 2. The non-labor inflation adjustment reduces their revenue requirement by about $1.2 million.
Very good, sir. Thank you. Thank you, Mr. Chairman.
Thank you. Any additional questions? Any questions based on Commissioner O'Donnell's question? Hearing none, the witness is excused. Thank you, Mr. Gorman.
Thank you.
Mr. McNutt, your next witness.
Thank you, Mr. Chairman. Department of Defense calls Mr. Christopher Walters.
Mr. Walters, if you could please turn on your microphone, raise your right hand, and wait for instructions.
Do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
I do.
Proceed.
Mr. Walters, by whom are you employed and in what position?
I'm employed by the firm Brubaker and Associates. I am an economic consultant.
And are you the same Christopher Walters who sponsored direct testimony and supporting exhibits filed on August 14th, 2020, and marked for identification in this evidentiary hearing as Department of Defense Exhibit number 2?
I am.
And Chris, you're coming in a little garbled to my ears. I don't know if you're a little far from the speaker. I don't know if anybody else has that issue, but I'm having a hard time hearing you. So you might want to project a little louder or get a little closer to your mic.
Apologies. And the answer to your question is I am.
And was that direct testimony and the accompanying exhibits prepared by you or under your supervision and control?
Yes.
And did you subsequently make corrections to Exhibit 1 of your direct testimony?
I did.
And were those technical revisions included in a notice of errata that was filed on August 17th, 2020 and marked for identification in this evidentiary hearing as Department of Defense Exhibit number 3?
Yes, it was.
And are you the same Christopher Walters who sponsored surrebuttal testimony filed on October 7th, 2020 and marked for identification in this evidentiary hearing as DOD Exhibit number 5?
Yes.
And do you have any additional corrections to your testimony or to any of your exhibits?
I have 2 corrections to my direct testimony and 1 correction to my surrebuttal testimony. Apologies for these. We'll start with the one in my direct. That will be page 45, line 8. I need to strike the sentence that starts with the result. Are we good with that one?
You need to finish what you're trying to strike, and then we'll move to strike it.
Understood. I would like to strike the entire sentence that reads, "The results of my risk premium analyses are summarized in Table 8.
Mr. Chairman, Department of Defense moves to strike that particular sentence from Mr. Walters' direct testimony.
Since on page 45, lines 8 and 9 are so struck.
Mr. Walters, do you have any other testimony that you would like to revise?
Yes, I would like to strike a sentence on page 6 in my surrebuttal testimony that begins on line 9 and carries through line 11. That sentence reads as follows. I find it curious as to why he would rely on such an observation with regard to my exclusion of Chesapeake Utilities, yet overlook the fact that he is the only witness to include Fortis in his electric group.
Mr. Chairman, the Department of Defense moves to strike on page 6, lines 9 through 11 of Mr. Walters' surrebuttal testimony.
That sentence is struck.
Mr. Walters, do you have any other corrections to your prior file testimony?
I do not.
Mr. Chairman, the Department of Defense moves DOD Exhibits 2, 3, and 5 into evidence with the prior.
No objection. DOD Exhibits 2, 3, and 5 are moved into evidence.
Thank you, Mr. Chairman. The witness is now available for cross-examination.
We'll begin the cross-examination by counsel for Maryland Office of People's Counsel.
Your Honor, I believe OPC counsel Gary Alexander is going to be crossing this witness, and it seems like he may be having some difficulties with his technical connection. So if you could indulge us a moment. Oh, there he is.
There we go. And 2. Thank you, Anna. And we have no cross.
Anticlimactic. Thank you, Mr. Alexander. The company.
Mr. Chairman, we have no questions for this witness either. Thank you.
Thank you, Mr. Herson. Mr. Spivak, do you have any cross?
No, Mr. Chairman, staff has no cross for this witness.
Do any parties have cross of Mr. Walters? Do commissioners have any questions of Mr. Walters? Commissioner O'Donnell.
Thank you, Mr. Chairman. Good afternoon, Mr. Walters. I asked you about a table in your direct testimony, your figure 1. which shows gas and electric ROEs from 2006 to 2020. See that?
Sorry, yes, I'm there.
Okay. Why? So clearly there's a downward trend in ROEs. They're pretty stable and have been, as you state, for the last 6 years below 10%. Why do you think that general downward trend since 2009 has occurred?
I don't know that there's any one specific answer for that. I think a lot of the followings have, or a lot of the reason why the cost of capital has gone down is because we've seen utility bond yields consistently come down. We've seen treasury yields consistently come down. All the while, we've seen utilities get be able to access ample equity and debt capital. So as they're accessing capital, the capital markets are ready. They're seeking to be a part of that growth and the growth in rate base and the stable dividend yields that utilities generally offer.
All right, very good, sir. Thank you. That's all I have, Mr. Chairman. Thank you.
Thank you. Other commissioners? Commissioner Herman.
Just 1 second, I'm checking my notes, so hold on 1 sec. Thank you. I thought I heard Miss. Were you listening when Mr. McKenzie? Oh.
Hear me now?
Yes, ma'am.
Okay, thanks. I thought I heard yesterday that Mr. McKenzie, in testifying, seemed to suggest that we should be looking at long-term forecasts, and that the long-term forecast are the forecasts that go beyond 2023. And our multi-year plan is through 2023. So can you give me your view on that? And I might not have gotten that exactly right, but I'm just looking at my notes, and I thought that's what I heard.
Can I ask a clarifying?
Of course.
Can you elaborate on which long-term forecast you would be referring to? Would that be interest rates, GDP, equity analyst, or otherwise?
That's probably a very excellent question, and I just wrote it down in my notes as long-term forecasts. So if you can't answer, it's okay. I think I was just trying to understand. I spoke to Mr. McKenzie about risk, and when we're forecasting, when we're looking at risk for the utility company, the BGE, I thought, was saying that we're not facing any risk from the pandemic. Our growth is steady. Our customers are saying they're moving ahead and everything else. But then Mr. McKenzie seemed to imply there was significant risk, and therefore we needed to give a higher return due to that risk. So
Understood.
I'm trying to understand the juxtaposition of those two positions.
I'm sorry, I didn't mean to cut you off there for a second. I believe, if I recall that conversation that you and Mr. McKenzie had, he was referring to the potential of capital market costs increasing during the multi-year plan. And correct me if that what my recollection was is incorrect. Okay. I would respond that while the company may face risks of increasing capital costs during that time, it's also equally likely that customers face the risk of decreasing capital costs over the same period of time. So that's how I would respond to that. I mean, there's risk on both sides whenever you lock in the cost of capital in such a fashion.
Okay, thank you very much. I appreciate it.
Certainly.
Any additional questions? Any questions based on the commissioner's questioning? All right, thank you, Mr. Walters. You are excused.
Thank you, everybody.
Mr. McNutt, do you have any additional witnesses?
No, Mr. Chairman, I was hoping we'd have longer cross there, but that was simple and easy. I'm all done. Thank you.
Thank you. Let me now turn to Maryland Office of People's Counsel. Do you have witnesses that are ready to testify today?
Good afternoon, Mr. Chairman, Commissioners. Joe Cleaver on behalf of OPC. Yes, Your Honors, we have OPC witness Cheryl Roberto, our first witness, ready to go.
Thank you, Mr. Cleaver. Do you have other witnesses ready to go today?
I believe that we've also arranged for Mr. Efron to be available. He's listed as the second OPC witness on our list. Those are the two that I know for sure can go. Not saying that no one else can, but those are the two that I'm sure of.
Okay, I don't expect we'll get beyond 2 more witnesses for the day. So if you'd like to call your next witness, first witness.
Thank you, Your Honor. The Office of People's Counsel calls Cheryl Roberto to the stand.
Mr. Roberto, if you could please raise your right hand and wait for the court reporter.
Do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
I do.
Yes, Mr. Cleaver.
Thank you, Your Honor. Good afternoon, Ms. Roberto. Would you
Good afternoon.
Would you kindly state your name for the record?
My name is Cheryl Roberto.
And would you please state the name of your business and its address and location?
I work for Synapse Energy Economics in Massachusetts, Boston, Massachusetts.
And would you please state the position that you hold at Synapse Energy Economics?
I am a senior principal.
Thank you, Ms. Roberto. Do you have before you a document entitled Direct Testimony of Cheryl Roberto, which was filed in this case on August 14th, 2020?
I do.
And does that document include 30 pages of narrative testimony, your CV, which is labeled attachment CR1, a Synapse white paper, which is identified as attachment CR2, and 3 data responses by the company to data requests?
It does.
Thank you, Your Honor. I would like to have Ms. Roberto's pre-filed direct testimony marked for identification as OPC Exhibit 1. And Your Honor, that is the number that was assigned to that testimony in our pre-filed exhibit list.
Thank you. I won't mark it in that case.
Thank you. Ms. Roberto, do you have before you a document entitled Surrebuttal Testimony of Cheryl Roberto, which was filed in this case on October 7th, 2020?
I do.
And does that document include 21 pages of narrative testimony and 4 data responses by the company to data requests?
It does.
And Your Honor, this testimony from Ms. Roberto, her October 7th surrebuttal testimony, has previously been marked as OPC Exhibit 2. Ms. Roberto, were these documents before you, were they prepared by you or under your supervision and direction?
They were.
And do you have any corrections or deletions to make to your testimonies at this time?
I do not.
If you were asked the same questions today under oath as were posed in your pre-filed direct and surrebuttal testimonies, would your answers be the same?
Yes, they would.
Thank you. And for these reasons, do you adopt your pre-filed direct and surrebuttal testimonies as your sworn testimony in this matter?
Yes, I do.
Thank you, Your Honor. I move that OPC exhibit numbers 1 and 2 be admitted into evidence.
Hearing no objection, OPC Exhibits 1 and 2 are moved into evidence.
Thank you, Your Honor. The witness is now available for cross-examination.
I believe only 2 parties have expressed examination of Mr. Roberto, the company, and staff, so we'll begin with the company.
Your Honor, no cross of this witness. Thank you.
Any cross by PSC staff counsel?
Staff has no cross for this witness either.
Just to be clear, any other parties wish to cross-examine Ms. Roberto? Do the commissioners have questions of the witness? Hearing none. Thank you, Ms. Roberto. You are excused.
Thank you, Your Honor.
Mr. Cleaver, you may call your next witness.
Thank you, Your Honor. Anna Ryan will be putting the next witness, Mr. David Efron, on the stand. Thank you.
Thank you. Mr. Efron, please raise your right hand and wait for instructions. And please turn on your microphone.
Can you hear me?
Yes, I can, sir. Do you swear and affirm under the penalties of perjury that the testimony you're about to give and the matter now pending is the truth, the whole truth, and nothing but the truth?
Yes.
Ms. Ryan?
Good afternoon, Mr. Efron.
Good afternoon.
Do you have in front of you the direct testimony and accompanying exhibits that was filed under your name in this proceeding?
Yes, I do.
And do you also have in front of you the revised surrebuttal testimony and accompanying exhibits that were filed under your name in this proceeding?
Yes, I do.
And were those documents prepared by you or under your supervision?
Yes, they were.
And at this point in time, do you have any corrections or errors, any corrections or changes to make to those documents?
I do not.
And would you give the same answers to those questions if you were asked them today?
Yes.
Your Honor, at this point, I would move the admission of the direct testimony of David J. Efron, which was labeled as exhibit number 3 on the exhibit list filed by OPC, and the revised surrebuttal testimony of David J. Efron, which OPC labeled as exhibit number 4.
Hearing no objections, OPC exhibits 3 and 4 are moved into evidence.
With that, the witness is available for cross-examination.
We'll begin with the examination by the company.
Your Honor, we have no cross for this witness.
Does PSC Staff Counsel have cross for this witness?
I'm forced to conclude we have no cross.
Thank you, Ms. Garofalo. I was expecting Mr. Dean. Does any other party have cross of Mr. Efron? Do commissioners have questions of Mr. Efron?
I believe I do, Mr. Chairman, but things are moving so fast, I'm barely getting my notebook pages turned. So if you give me a few minutes.
Yes. Let's take a 5-minute recess until 3:25.
Thank you.
In recess. We'll be back in about 1 minute or less. Right, the commission is back on the record. I'll wait for the commissioners to arrive. We'll begin the commissioner questioning by Commissioner Herman.
Good afternoon, Mr. Efron. Nice to see you again.
Good afternoon.
Mr. Efron, I'm going to ask you some big picture questions. So, as you've heard me ask some questions of BGE with respect to there being a rate increase. There is an actual rate increase, which is offset, but there is an increase. Do you have a view with regarding whether or not customers should be made aware of that increase?
That might be a little outside my area, but I think as a general matter, most customers wouldn't be familiar with the what I've called the special mechanisms being used by BGE to avoid rate increases for the first 2 years of the multi-year plan. I'm not sure there would be any easy and accessible way to convey to customers how those zero increases are being achieved in the first 2 years, if that was the question.
It is. It's it's a transparency question to a certain extent. So I appreciate that. Are you the OPC witness I should ask about Stride or no?
No.
Okay. So with respect to, I know in your direct, you talked about the inflation factor. Have you resolved that issue in your mind on inflation, or do you still have concerns with the BGE inflation factor?
I guess it depends what you mean by resolved. I updated the inflation factors in my testimony, and because of what the commission has done in past cases, I also adopted the consumer price index, although I think the GDP would be a better general measure. But that being said, with the updates, it's been reduced to the point where it's really not an issue of any substance anymore. It's still there, but the differences are pretty minor.
Okay, I thought that's where you were, but because you came up so quickly, I sort of hadn't had a chance to, prepare or get run back through things. I know you testified on the meter relocation and the inclusion of that. Isn't that right?
Yes, that's right.
Okay. Did you review the commission's order to determine whether or not you thought the company was in compliance with the commission's order on that issue?
Well, my understanding, and again, I did view the order at some point, and my understanding of the order was that they could begin to recover costs when it's complete. And the company's rebuttal testimony and the responses to the information, it didn't sound to me, I'm not an operations person or an engineer, but it didn't sound to me like it was complete. So therefore, based on my interpretation of the commission's order, it didn't sound like it was time to commence recovery.
Okay, thanks. What did I saw in your direct testimony, you were talking about property tax rates being too high. I had that right, didn't I?
The forecast of the increases in property tax, I thought were on the high side, yes.
Right, and I don't recall that in your any further testimony or changing views on property taxes. You maintain that view?
My rebuttal testimony did not change from my direct testimony. The only change in my rebuttal testimony was to update the property tax expense adjustments for the derivative effects of the plant adjustments sponsored by other witnesses.
Okay. So, Mr. Chairman, that's all I have right now. There was another question in there, but it took a hike and it may come back. So I'll come back in if any, after the other commissioners.
Thank you, Commissioner. Good afternoon, Mr. Efron.
Good afternoon.
I'm likewise trying to catch up. Earlier today, we heard from witness Vahos regarding contingencies and how contingencies, I believe he said they were less than $10 million a year, and that they use them sparingly only for IT and construction projects only. Is it your position that the commission should not allow any contingencies in this rate application?
I can only speak to the contingencies with regard to the operation and maintenance expense, and it's my position that the commission should not include those contingencies in the operation and maintenance expense included in the revenue requirement. With regard to the larger contingencies that apply to the construction project, that would be a subject for the other witnesses.
Thank you. I'll save my question for those witnesses. Any additional questions? Commissioner O'Donnell.
Thank you, Mr. Chairman. Good morning or good afternoon, Mr. Efron.
Good afternoon.
The beginning of your direct testimony, you seem to indicate in response to a question that, and correct me if I'm not paraphrasing that correctly, but you seem to indicate that because of the pandemic and the economic upheaval caused by the pandemic, that you agree with the mechanisms that the company undertook in this multi-year rate case to keep the first 2 years rates flat. Is that a fair accounting of what you said?
Yes. Understanding that this is also something of a policy consideration that I discussed with the public counsel attorneys.
But you also say that these mechanisms, although they may have a salient, not your word, my word, salient effect on the ratepayers now, ratepayers in the future are going to have to pick up the tab. I think that's generally what you said after 2023.
Yeah, there's a short-term benefit, but there's no free lunch in this regard. It means that customers in the future will be paying higher rates than they would have been in the absence of these special mechanisms.
And what's the magnitude of that?
Well, if you give me a minute, I had that in the direct testimony, as did Mr. Vahos.
I think it's like 450 million or something.
That sounds right. Yes.
Something in that neighborhood. Okay. And how should the commission think about that, in your opinion, sir?
Carefully. Well, I guess it's hard to put in other terms than what it is. We're in an unusual situation now, I think, to say the least. And again, it was the consensus of the OPC, the revenue I'm the revenue requirements witness, but the people determine the policy in the OPC, that on balance, that the company's methods of constraining the rate increases or freezing the rates in the next 2 years were worthwhile in the circumstances.
All right. Well, I appreciate the reminder again from both you and the company that there will come a day when these mitigating mechanisms will need to be taken into account. Thank you, sir, for being here today. I appreciate it.
Thank you.
Seeing no additional questions from commissioners, do any of the parties have questions based on those responses?
Yes, Your Honor, this is BGE. I do. I just ask your indulgence for a moment so I can pull up a BG exhibit. Yes. Good afternoon, Mr. Efron. This is Beverly Sikora from BGE. Has counsel for OPC given you copies or provided you with the data requests that BGE identified as being potential exhibits in this case?
Yes.
Okay, can you please turn to BGE Exhibit 35? And this is in response to Commissioner Herman's questions about the property tax increases that you trimmed down.
Oh boy, this might take a little bit of time. Was that a response to a data request?
Yes.
Could you because that's really the way I have my files organized.
Okay, it's 30-9.
This OPC 30-9.
Yes.
Okay.
Ms. Sikora, what BGE exhibit is this?
It is BGE Exhibit 35.
Yes, I have that now.
Okay, and this is a data request that OPC served on BGE and BGE responded to. Can you turn to the attachment on the attachment 1 revised?
I have attachment 1.
I'm sorry, attachment 1. Yes.
Okay, okay. I see that.
Okay, and in that, this is a year-over-year. I'm sorry, the annual property tax assessments by year, and then it shows the year-over-year growth rate.
I see that. Yes.
And you can see kind of a little bit right of center, there's a column for actual imputed 2021 or a column for actual imputed 2021 property tax costs?
Yes, it's imputed.
And what is does it show as being the year-over-year growth rate from 2019, 2020 to 2020, 2021?
Well, based on they're referred to as the actual imputed, they calculate 9.5%.
Okay.
That's imputed.
Correct, but what does footnote 2 to that column say? Does it not say that the imputed amount is based on the 8.5% increase from our actual notice of assessment received on September 30th, 2020?
Your Honor, I'm going to object to this line of questioning. This document was not prepared by Mr. Efron, and the document speaks for itself. If BGE wanted to have it admitted through one of its own witnesses, it could, but all that Mr. Efron is capable of doing at this point in time is reading it.
Your Honor, Mr. Efron has argued that BGE's imputed, the rate that BGE used is too high. This is, to show that it's in line.
BGE could have
I'm gonna weigh in.
its testimony as an exhibit if it felt it was necessary to support its arguments.
Okay, hold on a second. Commissioner Herman?
Thank you. I'm going to weigh in as well here. I just asked him if he had changed his position on rebuttal, and he said he had not. And BGE did not choose to cross-examine him on this issue. So I do have some concerns with this line of questioning myself based on my questions.
Ms. Ryan, with respect to your objection, I will sustain your objection. Ms. Sikora, anything else?
Nope, that's it.
Thank you. Any other parties? Mr. Efron, thank you for participating today. You are excused but not dismissed. You are subject to recall if we need you before the conclusion of the hearing at some point.
Thank you.
At this point, before we go off the record, do the parties have any matters they need to bring to the attention of the chair before we recess for the day?
Your Honor, can you hear me?
Yes, Mr. Nam.
This is Mike Dean.
Oh,
can you hear me?
Mr. Dean. Hi. Yes.
We had an internet outage here. It's slowly coming back, although the WebEx hasn't come back fully yet. I just wanted to say I didn't have any questions for Mr. Efron.
Thank you. I noted your absence earlier. We'll have that on the record. Okay. We are in recess until 10 a.m. tomorrow, Friday.
I did have something for the commission. I checked with Walmart's witness, Mr. Kronauer. He is now available tomorrow if that would assist the commission in the review of the case. He's still available on the times that we have listed for him. If that would provide a convenience, we can...
Let's take this off the record, Mr. Nam.
Okay, I'm sorry. Apologies.
Anything else on the record we need to discuss? Okay, this hearing is in recess until tomorrow, Friday, October 16th. We're off the record. Okay, Mr. Nam. Yes, we could accommodate Mr. Kronauer tomorrow if... Actually, let me ask Mr. Weishar first. Mr. Weishar, is Mr. White available tomorrow?
Yes, he is, Mr. Chairman. I've conferred with Attorney Ralph for BGE, and my understanding is he has no cross-examination for Mr. White, and Staff Attorney Spivak, I think, was the other attorney who had indicated the possibility of having cross for Mr. White. I don't know whether Mr. Spivak is still on the call, but we may be in position where we could waive cross and stipulate to the admission of Mr. White's testimony.
Mr. Spivak?
Mr. Chairman, staff will not have cross for Mr. White.
Okay, I don't want to speak for the commissioners. I'd still like to have the witness take the stand, even if briefly. Does that work for you, Mr. Weishar?
Certainly does. Mr. White will be available at 10 o'clock.
Okay. This proceeding has moved a little quicker today and taken us out of order. So I know, like myself, the other commissioners may need to reorder their preparation. And with respect to your second witness, he's still only able to testify on the 19th?
I can check on that, Mr. Chairman, see what we can move into tomorrow. I won't know that until later this afternoon.
Okay. Well, on my schedule, I have him for the 19th. If you want to move him back to back with Mr. White, we could do that and get you out of here. Okay, Mr. Nam, you said Mr. Cronauer is available tomorrow morning?
He is, yes, sir.
Okay, well, why don't we take him right after Mr. Weishar's witnesses?
Okay.
Okay. And then Office of People's Counsel, can we, depending on how things move with Amtrak and Walmart, can we bring the other, you have what, 5 more witnesses? Can we have them ready to go?
Yes, Your Honor. They are all prepared to testify tomorrow.
Right. Well, if we get through all those witnesses, we'll be ahead of schedule, and then we'll save staff for next week. Anything else before we call it a day? All right. Well, I just want to appreciate everybody. I know we had a lot of technical difficulties this morning. It's difficult in a virtual environment, but I think we're making good progress, and I know our court reporter is doing her best to get the rush transcripts to those who have purchased them. So thank you, Linda. Everybody have a good